Appellates, Lordship.
Yes, Mr. Pal, what is it?
Lordship, yesterday, Lordship, grant me leave to move on urgent matter, Lordship.
Yes.
It's appearing at item number 38, Lordship. Lordship, I am proposing, Lordship, kindly, if it is not taken up by 3 p.m., Lordship, kindly take up it at 3 p.m. I shall serve notice on that.
Please.
Much
Yes,
obliged.
yes.
One correction is there, one last occasion, interim order date is.
Origin side or appellate side? Mention on Monday. I'll keep it on the next day's list and do it. Mention on Monday. Yes.
Origin side item number 1.
The IPF for the petitioner.
Yes, sir.
I have concluded my submission. Mr. Mukherjee, Shomit Mukherjee was to address the court. And Mr. Pal also.
In the meantime, I submit, my lord.
Please.
My lord, in this matter, I am happy submitting on behalf of the private respondent number 3, my lord. That is respondent number 3, my lord. My lord, in this matter, my lord, Mr. Dotto, my lord, in his submission, my lord, from beginning to end, my lord, submit that the instant contract is a works contract. But at single moment, my lord, Mr. Dotto did not place the contract, the relevant contract, my lord, before lordship, my lord. My lord, kindly first, my lord, examine the contract which is at page 186 of the second volume, my lord.
Yes.
(186), my lord.
Good.
My lord, kindly, my lord, see, my lord, at the top, my lord, it is a purchase order. It is not a works contract or works order, not there. Only purchase order, and purchase order cannot be a works contract. My lord, then, my lord, kindly come to title. And then, my lord, please supply the following items. Public service as per the terms and conditions mentioned below and its attachment, my lord. Here the, my lord, private respondent, my lord, obliged to supply, my lord, 1 to 66 items, my lord, and 67 items, my lord, is the items of 1 to 66 items to provide service, my lord. Kindly, my lord, see, my lord, page, my lord, 186 to 192. All are the, my lord, supply contract, supply items.
The erection of pipelines is not.
No, my lord. This is, my lord, the service, my lord. This is the service. 1 to 66 is the item to supply, and 67 is the, my lord, provide service, my lord. And that is the heading, my lord, the supply of following items and service. And then, my lord, kindly come to, my lord, page 186, my lord, deliver. Not works, my lord, delivered. Means, my lord, Hindustan Petroleum Corporation is, my lord, purchasing.
What is that delivered?
My lord, just, my lord, supply the next, my lord, delivered to 186 page.
186 years.
Please supply the following items and service, my lord. Find it, my lord.
Yes.
Middle, my lord, delivered to the place where the items will be delivered.
Delivery would obviously connect the supply.
Supply. I am that, my
But
lord.
the
I am
caption is also title. Title is also supply
and erection of
erection.
pipes and accessories, my lord.
Both are there.
Both are
And
there.
erection.
And then, my lord, please supply the following items and service as per the terms and conditions mentioned below in the attachment, my lord. Then, my lord, kindly come to, my lord, section, my lord, 2D of the, my lord, MSME Act. Buyer, my lord.
Buyer, yes.
Buyer means whoever buys any goods
I'm sorry.
or receives any service from a supplier for consideration.
Yes.
Here, my lord,
Right.
purchase order issue, my lord, for buying, my lord, these items, my lord, and service is also there, my lord, The following items are, supply the following items and service. Services are also there. That means, my lord, the petitioner is the buyer. And then, my lord, come to, my lord, the findings of the, my lord, MSME Council, my lord, which is at page, my lord, 404 of the, my lord, third volume.
Petitioner is not the buyer, you are the buyer.
No, my lord, petitioner is the buyer.
Means
Petitioner
Buyer
received
means whoever buys any goods or receives any
from me,
services.
my lord, he buys, my lord. Purchase order issued by the petitioner, my lord.
Yes.
My lord, 404, my lord.
But and is not satisfied. Buyer says means whoever buys any goods or
Receives any service.
So he has the capacity of a buyer as well as a
He received the service from
buyer
me.
in
My lord, he has received the service. That's why, my lord, in the contract made itself, my lord, it says, my lord, the following, supply the following items and service. My lord, page
he
186.
supplies the service, then you are receiving it, not him.
Yes, my lord.
He is purchasing the property
Purchasing
and
the
supplying them to you.
to you.
So you are receiving the supply.
Service.
Therefore, he cannot be a buyer under this. Or maybe he has both components.
Both component.
You can argue that that buyer in respect of the goods and service and
Can receive the service, my lord.
service. Yes, right. Very well.
And then, my lord, kindly come to, my lord, 404 of the, my lord, MSC Council, my lord, findings, my lord, decision, my lord. Page, volume 3, my lord.
Page.
Page, my lord, 405.
Yes.
My lord, regarding in case of works contract, MECD Act does not apply. My lord, that headings, my lord. My lord, point, my lord, 1, 2, 3, my lord. Kindly come to 3. Section 2N of the MSMED Act define that supplier means any micro or small enterprises which has filed a memorandum with the authority. Herein, as per Section 2N of the Act, the said supplier unit filed a memorandum with the authority. Now, the Udyog Aadhaar memorandum of the applicant shows that the unit is small, having activity type of service. So, as per the provision of the Act, the claim of the applicant is very much under the purview of the Act. My lord, kindly come to, my lord, section, my lord, 2N of the MSME Act, my lord.
To end the authority
Supplier
says
means my
it was
supplier.
satisfied. It is
Ah.
said that it is satisfied.
Satisfied. 2N.
So he's a supplier also.
Is a supplier also. So, my lord, buyer and supply relationships, my lord, is there, my lord.
He has both components. The components of a buyer, as per your argument, because he satisfied the first limb of 2D, and also a supplier as per 2N.
2N.
So he is both.
Both.
You cannot say he is not a supplier. I mean, I'm sorry, he not a supplier. He did not do the work.
My lord, I am a supplier. Supplier is the respondent number 3 is the supplier, my lord. Not the, my lord, by Hindustan Petroleum, my lord. The petitioner here in, my lord.
Achha, right. Very well.
I am the supplier.
All right. All right.
And supplier and service provider, my lord. I am, my lord.
Right. Right.
Not the petitioner, my lord.
Yes, you have both components.
Both components.
I'm sorry.
So,
Yes,
my lord,
you're right.
buyer and supply relationship is, my lord, established, my lord. Then, my lord, come to, my lord, I have referred a decision, my lord. Just a minute, my lord. My lord, 2022 SCC online on the Pradesh 2013, my lord.
Have you got a copy of that?
Yes, my lord, I have already given.
2013.
2013. Dolapati Construction represented by its partner.
Yes.
My lord, here, my lord, paragraph 1 to 4 is the just, my lord, facts of the case, my lord. And, my lord, paragraph 19 to, my lord, 14, my lord, is the consideration of the court, my lord. I'm reading, my lord, paragraph 9.
Yes.
This court at the outset would place on record that this court is not going into the merits or demerits of the respective claims of the claimant and the third respondent, the same would have to be adjudicated upon by the authority, which would be competent to adjudicate on such claims. The issue in the present writ petition revolves around the interpretation of the provisions of the Act. The Act had been enacted for facilitating the permission, development, and enhancing competitiveness of micro, small, and medium enterprises, and for matters connected thereto and incidental thereto. The scheme of the Act is as follows. The Act would apply to micro, small, and medium organizations which answer the definition enterprise contained in section 2E, which is as follows. Section 2E, the enterprise definition is there. Thereafter, paragraph 12. Any organization answering this description would be categorized as a micro, small, or medium enterprises depending upon the quantum of investment made in the enterprise. Any enterprise which seeks the benefit of this Act would have to file a memorandum of the enterprise before such authority, and as may be specified by the state government or central government. Once the said memorandum is registered with the said authority, the enterprise would be entitled to the benefits of the Act. Thereafter, my lord, any enterprise which has not been paid its dues on account of supply of goods or services to any buyer, my lord, here the petitioner is buyer, would be entitled to approach under section 8 of the Act, the Micro and Small Enterprises Facilitation Council for recovery of its dues, along with interest specified in section 17 of the Act. When any application is made under section 18 of the Act, the Facilitation Council shall either itself conduct conciliation or seek assistance of any institution or center to carry out such conciliation. In the event of the conciliation not being successful, the council can either take up the dispute for arbitration or refer to it any institution or center for such arbitration, and the provisions of the Arbitration Conciliation 1960 Act, and shall then apply the dispute as the arbitration was in pursuance of the arbitration agreement referred to in subsection 1 of section 7 of the Arbitration Act. My lord, thereafter, my lord, kindly come to my lord, paragraph 19 to 22, my lord. The second respondent council had taken the view that even though the petitioner was registered under the Act, the dispute cannot be taken up by the second respondent. My lord, the second respondent is MSME council, my lord, on the ground that the transactions of the sale of plant and machinery is a trading activity. This view is assailed by the petitioner on the basis of the judgment of a learned single judge of the Honorable High Court at Bombay in Shah and Parikh Engineers and Constructors versus Urmi Trenchless Technology Private Limited. The learned single judge, while dealing with the similar issue at paragraph 22, had held as follows. As regards the other defense is concluded, dependent number 1 is admittedly a small enterprises registered under the MSME Act. The registration certificate is annexed exhibit 1 to the affidavit in support of notice of motion number so and so filed by defendant number 1 under section 8 of the Arbitration Act. The registration certificate is for horizontal boring, which is nothing but drilling activity. Plaintiff in the course of the argument did not dispute that dependent number was registered under the MSME Act. But here the petitioner not dispute that, my lord, but merely sought to contend that the work forming the subject matter of the contract between the parties was not the same activity for which the dependent number 1 had been registered. However, as stated above, this misconceived as horizontal boring is in fact a drilling activity. Further, there is nothing in the MSME Act which provides that the registration for a particular activity will render an enterprise liable not to be regarded as a micro, small, or medium enterprise for any other activity. Once registered, the status of the enterprise is that of a registered enterprise under the MSME Act, and all the provisions of the MSME Act has to apply with full force. Therefore, I am in respectful agreement with the said principles enunciated by the learned single judge of the Honorable High Court of Bombay. In that view of the matter, the decision is allowed, my lord. Thereafter, my lord, I am the next limb of submission is that, my lord, in writ jurisdiction, my lord, the writ court cannot decide whether a contract is works contract or any other nature of contract, my lord. In this respect, my lord, I am submitting one Supreme three-bench judgment, my lord. Bhavan Construction, my lord, 2022, one Supreme Court cases, 75 page 75, my lord. In paragraph, my lord, 25, my lord. 2022, one Supreme Court cases, page 75. My lord, paragraph 25, my lord.
Yes. 25.
In the Gujarat Act, my lord, described in paragraph 4, my lord, it is a, my lord, Gujarat Public Works Contract Dispute Arbitration Tribunal Act 1992. In paragraph 4, it is stated, my lord. In Gujarat Act was enacted in 1992 with the object to provide for the constitution of a tribunal to arbitrate dispute particularly arising from works contract to which the state government or a public undertaking is a party. A works contract is defined under section 2K of the Gujarat Act. The definition includes within itself a contract for supply of goods relating to the execution of any of the works specified under this section. However, a plain reading of the contract between the parties indicates that it was for both manufacturing as well as supply of bricks. Importantly, a contract for manufacturing, simply stated, is not a works contract under the definition provided under section 2K. The pertinent question, therefore, is whether the present contract, which is a composite in nature, falls within the ambit of the works contract under section 2K of the Gujarat Act. This is the question that requires contractual interpretation and is a matter of evidence, especially when both parties have taken contradictory stance regarding this issue. It is a settled law that the interpretation of a contract in such cases shall generally not be done in the jurisdiction. And my lord, and third, I am referring another judgment, which is, my lord, most probably unreported, my lord. This is our Honorable High Court's judgment. And that is, my lord, Justice Mousumi Bhattacharya's judgment, my lord.
Give a copy to them also, Mr. Pal.
Huh?
You have to give a copy to them also, because if it's unreported, AP 831 of 2018. Date is 5th of April. Justice Mousumi Bhattacharya. On which proposition, Mr. Pal?
My lord, the same principle, my lord, in paragraph 9, it has start from paragraph 9, my lord. Same provision, my lord.
Same means the last one you cite.
Yes, sir. My lord, first one.
First one.
First one. My lord, but in paragraph 9, my lord. My lord, this is same, my lord. I am not repeating that, my lord. That is same, my lord. Just I am.
Which paragraph should I look
my lord,
at?
9, 10, 11, 12, 13, and my lord, 18.
Not 23.
Not 23. No, 21, my lord. 21. And 23 years, my lord.
You have marked.
Yes, 23. Wait. 23. And my lord, then my lord, again, my lord, come to my lord. My lord, the decision, my lord, taken by the my lord MSME Council at page, my lord, 404, my lord, in column 3, my lord. It is, my lord, 406, my lord.
Which one?
My lord, 406, my lord, from my lord, second, my lord, point.
406 of the
page, the third volume. Third point, my lord. Volume 3, my lord.
Got it. Yes.
My lord, in pursuance of section 11 of the MSME Act, Public Procurement Policy for Micro and Small Enterprises, Order 2012 and amended in 2008, envisages the procurement of 25% goods and services produced and provided by micro and small enterprises also gave exemption and submitting tender cost, AMD, etc. My lord, I am, my lord, according to this, I am enjoying that benefit, my lord. And my lord, in case of works contract, any micro and small enterprise shall not be entitled to get benefits under Section 11 of the MSAD Act 2006. And that is the procurement preference policy and public procurement policy for micro and small enterprises limited 2012, my lord. And if it is whatever, he will not get the benefit, my lord. Section 11. But that is my service.
Mr. Pal, what would be the position according to you if it's a composite contract? Both a works contract and
But it is not from the, my lord, contract, it is not.
no, then what will be the legal position? Then it will not be taken up by the council.
If it is a works contract, my lord,
As
then
elements of a works contract, then it cannot be taken. up.
that is not, no, my lord. That is
Your
not,
case-
my lord. There is no prohibition in the, my lord, MSME Act that what contract is prohibited. There is no provision, my lord. There is
Where
no
do we get
provision.
it?
And my lord, on the High Court
Let us
says,
come to section 11 because that has been
yes, my
uh,
lord.
referred to by the authority.
And that is not, well, whatever nature of the contract, if I registered with the MSME Act, I will enjoy all the provisions of the MSME Act. If I registered, my lord. Section 11, my lord, procurement of preference policy, my lord.
That is
For,
different.
for facilitating the promotion and development of micro and small enterprises, the central government or the state government may, by order, notify from time to time preference policies in respect of procurement of goods and services produced and provided micro and small enterprises by its minister of departments, as the case may be, or its added institution and public sector enterprise. My lord, since, my lord, I am service, I am also service, my lord, and supply, my lord, both are giving, my lord, so I am enjoying this, my lord.
Very good. Yes, Mr. Mukherjee.
No, yeah. Ayyo.
আচ্ছা উনি যেগুলো দিয়েছেন জাজমেন্ট সাইট করেছিলেন ওগুলো কোথায় এখানেই আছে মিস্টার দত্ত এগুলো দিয়ে একটা জায়গায় করে
তুমি তো অনেকক্ষণ বলবে মোটামুটি
Yes, Mr. Mukherjee, anything else apart from what you submitted just now? Yes.
Not for your lordship.
No, definitely not.
I was about to ask, but the difficulty is that I'm
Yes.
cautioned. So I shall not bring that.
Definitely. Yes, what is your point?
But may I first take your lordship to the statement of objects and reasons of the act. Lord, your lordship has got that book?
Yes. Right.
Lord, I understand that book has a very short, the entire objects and reasons may not be appearing there. Lord, may I in that case hand up my book to your lordship, Lord? If your lordship will kindly take the trouble of
Can,
going.
no, this is what is given here, probably the same. Just check up once, please.
My lord, my lord.
This is LexisNexis, but it appears to be the same.
Yes, my lord. It's the same.
Statement of objects of reasons generally.
Lord, may I
No,
seek
this
the
book has
indulgence, Lord, to come back on some other day to reply? If your lordship feels,
Immediately after the statement of objects and reasons, or you're saying this? Is there anything in the? They have a point here then.
no.
Very late. Right. Yes, Mr.
I'm
Mukherjee. You are for the authority. Right.
May I please? Small scale industry, that I am starting from it, be it enacted by the Parliament in the 57th year of the Republic of India as follows.
Mr. Mukherjee, can you give me an idea why you are placing that? I mean, what is your thrust?
Lord,
So that because
My-
there are other motions also, that's why
My-
just I
my-
want to get
my-
the crux.
my lord, I shall be very short in that case. In fact, I have filed
No,
my
no,
lord,
take your time, but
one
just give me
page
the.
notice also there.
Oh,
which practically
Sums
chalks
up.
out the or sum and
Just give me an
substance of my.
indication what is your thrust of argument?
Well, at the statement of objects and reasons, it will be very clear after going through that the act was practically formulated for the safeguard of this medium and small scale industries. Because what happened that normally they were thrust against the giants practically for the purpose of, if it's a large scale industry, that is why it's eliminated. It's not stated here. But the small and medium scale industries, they were finding it very difficult that when they had certain dues from their opponents and they were economically more powerful, they were dragged into either a suit or an arbitration. Now, that is why the governments, my lord, the legislature thought it fit that the government should come forward with an enactment so that they are protected. And there are certain stipulations in the act itself which show some sort of leniency to this medium and small scale. Like it starts with conciliation. Automatically, if the conciliation fails, the same the entity practically or the same tribunal or the same person can take up the arbitration, which is practically prohibited in the Arbitration Act.
So the interpretation should be in that light.
So
Interpretation of
it has to be taken in a lenient way.
Very.
Secondly, my lord, if it's a suit or if it's an arbitration, it goes on. But here there's a stipulation that once the MSME Council takes it up, it has to be completed by 90 days. So there's a stipulation already given. My lord, thirdly, what I would suggest is that here what has been stated throughout the Act, that there's a differentiation in between goods or services. Practically only at one place, the statute says it's good and services. So practically based on this, there may be an argument that look here, works contract is essentially concentrating on the supply of goods and services. It's not goods or services. So you cannot bifurcate. So it's a composite contract. Yes, it is definitely a composite contract. But all such cases where goods and services are being supplied are not works contract. For example, beloved, suppose we are enjoying the telephone services, the cellular services. Now here what is happening, it is basically the service that we are enjoying. But so far as the goods part is concerned, it's the SIM card. Similarly, my lord, suppose I go to a restaurant, I order some food. Now there also, I am being served with the food by a person who is rendering his service. And there's a charge for that. The
For the
restaurants are-
parcel, the pack also maybe.
Yes.
So that's a part, that's a minor part.
So
dominant
whichever,
purpose, that principle comes in.
now here there's a speciality. Speciality means the person who is asking for the goods, rather the supply of the goods and services, like the question rose in the case of Kone elevators. Now, suppose somebody supplies me with an elevator, I cannot fix it myself. I'm in requirement of it. I've ordered. So that is why it's a case of works contract that please come to my premises, you fix it up because there are certain measurements to be made. So here works contract comes in. But the statute is practically silent on this issue that works contract is totally eliminated. So far as MSME Council is concerned, it cannot take up cases of works contract. It is practically a judicial creation. There are certain high courts which had practically relied upon certain judgments of tax laws, and my lord, they have come to a conclusion, their lordships have come to a conclusion that works contract is eliminated so far as MSME is concerned. Why? It's a special type of a contract. It is a composite contract. But even if it's a composite contract, bifurcation is possible. Like in the billing system, even in cases of works contract, my lord, there may be a separate bill for the materials which have been supplied and there may be a bill for the services rendered. Again, it may be a composite bill also. Like I ask a painter to paint my room. He may charge me separately for the paint packs as also the labor, or he may charge it by per square feet. That this is the cost you have to pay. I shall be supplying man as all and materials. Also simultaneously, the genesis as to why this works contract was stated to be a special type of a contract, that has also to be examined. Now, this is practically born in the tax case laws. Initially, what happened, Millard, the distribution of the tax in between the center and the state was like this. Initially, it was sales tax, later it was VAT. So what happened? The state had the exclusive jurisdiction of taxing this sales tax laws, rather the sales tax. Now, subsequently, the states found that in the garb of works contract, a substantial amount of tax is being rather avoided, if not evaded. So the amendment was brought in that works contract was also treated to be included in the sale, in the definition of sale. Now, it continued for some time. Now, the Parliament thought it fit after an amendment came, Article 366, within brackets 29, capital A, where there came a bifurcation. Service tax law was also introduced. Now, there was a tussle in between the state legislature, rather the state executive and the central executive as to who is going to get the tax out of it. Because the same transaction, the state said it's a sale, and the same transaction, the center said it's a service. So we have the right to tax it. So Parliament made it absolutely clear, and I have also indicated in my note that in the recent GST laws.
One second. Note. Note. The respondent authorities. Yes, thank you. Please continue.
Well, may I just, will excuse me for a minute. Yes. So the Parliament has made it absolutely clear,
right,
in the GST laws that yes, now it's a composite tax in the way that center gets its part, state equally gets its part, and works contract becomes an included portion in the transaction, but with a special rate. Now, so far as this MSME Council is concerned, my lord, since my respectful submission is that, yes, there are judgments against us that the council does not have the power to bring within its ambit those cases of works contract or adjudicate upon it. But just kindly, your lordship would appreciate the alternative. Suppose there is an arbitration clause. Now, what is happening? The party which is practically challenging itself, and there had been cases also, because in spite of the existence of the MSME Council and the party being registered with that, the other side has approached an independent arbitrator based on the agreement. Now, the consequence is the same. It is the same arbitration that is being adjudicated by this council. So in the alternative, it goes to some independent arbitrator, maybe by choice of the parties or maybe appointed by the Honorable Court, where the parties are submitting for this purpose of adjudication. Now, my respectful submission, in very short, I would say that since this is a beneficial legislation which is meant for the benefit and for the subsistence of the medium and the small scale industries, the MSME Council has the authority also to adjudicate upon this, because of the sole reason is that just because it's good and services, yes, my lord, here I must also rather amplify a bit. had it been the opposite, rather had the legislature used the word goods and services, then it could have meant only those contracts or only those transactions which include goods and services, like the one in the restaurants, or in cases of works contract, they only come within the ambit or the jurisdiction of the MSME Council. So that is why the legislature has purposely made it or disjunctive. So here, if it is necessary for the purpose of these sorts of composite contracts, it has to be read as and not as or.
Very.
And lastly, my lord, that is all right, my lord, I shall end my submission here. I shall not elaborate any further. These are my submissions. my lord.
You can, because there's a somewhat new light being shed on this, because the other judgments don't deal directly with this component.
Yes, my lord. Yes.
As far as was cited before me, at least, you would not find this component there. Mr. Mukherjee, one other thing, you have to thrash that out also. Now, you are saying that if there is a beneficial interpretation, if it's a beneficial piece of legislation, it is obviously for the MSMEs.
Right.
Now, if the interpretation is to be beneficial, it is to be in favor of the MSME authority having jurisdiction to adjudicate. Now, how is that per se beneficial to the MSMEs? The time limit, due to the short time limit, how can we say that the MSME authority is better than some other quasi-judicial or arbitrator, or
We are-
how can we say that? Why can
we are, my lord, so far as MSME Council is concerned, I shall not submit that MSME Council is a better arbitrator than the person who would have otherwise adjudicated.
we cannot
definitely
proceed
not.
on that presumption that
But there's an advantage. What happens is that the MSME Council, usually it's a tribunal sort of thing with number of arbitrators. Now here, every member of the tribunal is an expert in its own field. It has chartered accountants. He may be a retired engineer from different fields. He may be a social worker, like this. Now, normally, we don't get the benefit of so many, I would say, intellectual brains in normal arbitrations or ordinary arbitrations. At best, it may be 3, like 2 arbitrators, 1 umpire, like this. And Millard, if I may add also simultaneously, it has a practical difficulty also. Now, suppose for some reason or the other, today, because MSME has got nothing to do, because it is not an aggrieved party in that way.
no, how can?
Because the parties are the petitioner and the respondent number 2. Sorry, respondent number 3. Now, only the role of the MSME Council here is that just because the government has given it the jurisdiction as per the statute it feels, so it is eager to adjudicate. Suppose today the Honorable Court holds no, like in other cases, in other states also, where it has been held that no, MSME Council does not have the jurisdiction, it will be relieved of its burden in that way.
No, Mr. Mukherjee, that's why you are the most neutral authority, neutral within courts
Yes.
in this matter, to be asked this question about the interpretation of the statute and submit it either way, and why it is against you, why it is in your favor. And you are the best neutral authority here in this matter, at least. Should be, ideally at least.
Well,
Which you are basically. So, anyway, so the composition is one of the aspects, because I am going into the grain of the matter. I mean, because why is it beneficial? Apart from the experts, the time limit also probably, because arbitration at time limit is more.
and there are other differences also, which has been specifically stated in one of, I understand, there's a judgment of the Gujarat High Court probably, where there the difference between the Arbitration Act and the proceedings under the MSME Act has been stated. So I can give you a lot.
So it's tweaked a bit in favor of the MSMEs,
Yes.
which is the purpose of this statute.
And suppose it fails in that case, suppose the MSME cannot provide this protection to the medium and small scale industries, if they cannot thrive, they are practically, Willard, so far as the economic scenario is concerned, practically 80 to 90% of the Willard, the players there.
The purpose will be frustrated then.
Purpose will be frustrated.
Very good. Thank you. Thank you very much.
If your lordship wants further assistance or any elaboration on any point, I'm ready to it. But today I am a bit handicapped, really speaking. So that is why
I'm sorry. No, Mr. Mukherjee, it's all right. I've got your point.
grateful.
I think I've got your point. Yes. What reply?
Well, Mr. Dotto
Oh,
is
he's
leading in this matter, my lord. My lord, just for half a minute, my lord, subject to my lord's kind correct.
If he has to reply, he has to reply.
Yes,
Not knee-jerk reaction like this. You get ready in your matter and come back, you can give the reply also. I have no qualms on that.
No,
But
ma'am.
somebody, one person has to give the reply.
I will just-
So when do you want to come back? Come back on Monday because it's a
My lord,
continuing matter.
Monday, he just has, he's not there on Monday, my lord.
Oh, achha.
My
When
lord,
should I keep it?
my Tuesday or Wednesday, anytime, my lord.
Tuesday then, yes.
Tuesday.
At order. Heard learned counsel for the private respondent as well as the MSME counsel. Full stop. For reply by the petitioners, the matter is adjourned, comma, on the prayer of the petitioner till June 13, 2023.
Deeply obliged, my lord.
Thank you. এগুলো সব এরম ভাবেই থাকবে, হ্যাঁ, এখানে এটা তো থাক আলাদা। এইগুলো সব একসঙ্গে থাকবে, জাজমেন্ট গুলো আর ওনার যে নোটসটা ফাইল করছে।
Extremely grateful.
Next step.
Item number 2,
2 and 3 are similar, my lord. This is on the point that a document relied on by the identification committee while deciding whether there is a willful default will have to be supplied. Documents relied on in the course of the proceeding will have to be given. This was one of the points. My learned friend was to take instruction whether this has been given to us or not.
My lord, I have obtained instructions from the respondent bank. My lord, it appears that the documents in question were not supplied to the petitioner, admittedly. My lord, which leads to the impression that they did not have the opportunity of relying upon them or arguing with respect to them at the time of the hearing, and decision was taken without supplying a copy thereof. My lord, in this situation, to be fair to my learned friend, if my lord, it's my lord's pleasure to send it back for fresh hearing, I'm sure that a fresh hearing will be granted to the petitioner by the identification committee.
I'm also sure about that. If I relegate it to the committee, it will do that. Regarding that, I have no qualms. But what is your stand on this? If the documents were not given, then why waste further time? I
Yes,
mean,
ma'am.
I think on that score, limited score, but on the merits, obviously, I can't go into the merits.
So your
But
lordship
then
will
your
give-
identification goes.
Yes,
I have
my
to
lord.
set that aside on that.
That is the effect, my lord.
your
Anyway,
lordship will keep the point of vagueness of the charge of the
all the
so-called-
points are kept open regarding every aspect of the matter. I'll not specify any
Very well,
particular
very
point.
well.
Mr.
Yes,
That will create a
Yes,
stress
yes,
on a
yes.
particular point. It may go either way. Ashu. Learned counsel for the petitioner takes an objection to the.
my lord, I'm sorry, your lordship's last order has
Oh,
this very detailed recording.
I'm sorry.
My lord can just probably copy paste from there.
Very thank you. আচ্ছা তাহলে এটা কেটে দিন আমি বলে দিচ্ছি থ্যাংক ইউ ভেরি মাচ The present petitioners have challenged a declaration of willful defaulter by the identification committee on several scores, full stop, apart from the argument that the show cause notice issued for such hearing was vague in the absence of disclosure of particulars, comma, learned counsel has also argued, comma, inter alia, comma, that all the documents relied on by the committee were not supplied to the petitioner prior to the hearing, comma, in particular, the forensic audit report, which formed the plinth of the decision of the committee, comma, which would have enabled the petitioner to effectively argue the matter and present its case. Full stop. Next para. Learned counsel appearing for the respondent authorities, comma, in his usual fairness, comma, upon instruction submits that the documents in question, comma, including the forensic audit report, comma, were not handed over to the petitioner or served on the petitioners prior to the hearing. Full stop. Next para. Hence, comma, instead of going into the merits of the matter and prejudging the same at this stage, comma, it would be best for all concerned if the matter is remanded back to the identification, remanded hole back hoy na, is remanded to the identification committee for the purpose of giving a fresh hearing to the petitioner upon prior service of copies of all documents, including the forensic audit report, on which the committee intends to rely for adjudicating the issue. Full stop, next para. Accordingly, WPO 1141 of 2023 is disposed of by setting aside the declaration of willful defaulter of the petitioners and remanding the matter to the willful defaulter identification committee for the purpose of giving a fresh hearing to the petitioners, upon prior service of copies of all documents, including the forensic audit report, on which the committee intends to rely, sufficiently in advance of the date of hearing. Full stop. Such copies shall be served on the petitioners, preferably within a fortnight from date. Full stop. Next para. Simultaneously with the service of copy, the committee shall fix a specific date and time as well as venue of hearing on the question.
Sorry, may I? Lord, once they give it, in law, I'm entitled to give a representation. So if I could deal with that also.
Right.
So hearing would include the opportunity to give a written representation dealing with the additional
আচ্ছা,
document.
fix a date of hearing, কি বললাম? Just এখানটা ছেড়েছি একটু বলুন। হ্যাঁ। অফ হিয়ারিংটা কেটে দিন, ওখান থেকে অন্য জিনিস করে দিন, সেন্টেন্সটা কন্টিনিউ হবে। হ্যাঁ, venue for the petitioners to file their rejoinder, if any rejoinder stroke objection, if any, full stop. Thereafter, the committee shall fix a specific date for affording hearing to the petitioners on their rejoinder stroke objection and decide the issue in accordance with law. Full stop. Next para. It is made clear that the entire exercise shall be concluded by the willful defaulter identification committee as expeditiously as possible, positively within 2 months from this date. Full stop. It is made clear that the merits of the contentions raised by the parties have not been gone into, and it will be open to the identification committee to adjudicate all issues independently and in accordance with law without being swayed in any manner by any of the observations made here.
Lord, would
My
it be
lord,
allowed-
only
Yes.
one thing, my lord. Instead of fortnight, can it be 4 weeks, my lord?
Fortnight for what did I give?
Communicating all the documents to the petitioner, my lord.
Not a fortnight.
Instead of a fortnight, can it be 4 weeks, my lord?
4 weeks will be too much. Give it within a fortnight.
If they want
You have
4
got the
weeks,
copies, you have relied on those are
if
in
they
your
want
office.
4 weeks, let them have 4 weeks. I will have to come back again.
Could be shorter, maybe.
Very well, my lord.
But one thing, would it be your lordship's consideration to direct that this will be a de novo consideration? That word might have a legal implication. Kindly considers it. That there will be
Yes.
there will be a de novo consideration of.
কোথায় রিমান্ড কথাটা কোথায় বলছি, কন্ট্রোল ফাইন্ড করে নেবেন। রিমান্ডেড টু দ্য আইডেন্টিফিকেশন কমিটি, রিমান্ডেড ফর আইডেন্টিফিকেশন কমিটি যেখানে লিখেছি, রিমান্ডেড কথাটা পরে ফর আ ডি নোভো কনসিডারেশন।
I'm very grateful.
রিমান্ড যেখানে আছে একটু কন্ট্রোল ফাইন্ড করে তারপর ডি নোভো কনসিডারেশন, ফর আ ডি নোভো কনসিডারেশন। এটা দিয়ে দেবেন, আপনি ঢুকিয়ে দেবেন, আমি দেখেন ওটা বোল্ড লেটারে দিয়ে দেবেন, আমি করে নেবো।
But my lord, this would not affect the validity of the show cause notice.
Why should we? I haven't said anything on that.
Nothing is whatever is right.
If the hearing is to be given, it has to be given on the show cause notice itself. And where is the question of rejoinder or objection unless there is a show?
This is next matter would also be the
Same, my
Two
lord.
anti-similar orders.
same.
What is the similarity that the same willful defaulter
Same,
declaration?
your lordship has thankfully not specified a
petition
date,
as
so
well.
the exact order
তাহলে
can
ওটা plural করে দিয়ে same act composite order করে, a single order করে দিন।
My lord, only one thing with respect to the communication of the documents. I am instructed that there might be changes in the management of the respondent bank for which they need to coordinate amongst themselves for communicating. the
Coordinate within a
requisite-
week,
Very well, my
sir,
lord.
within another week.
Very well. my lord.
How long does it take to serve documents nowadays? You can do it by tomorrow.
Yes,
You
my
have it in your records, just email them copies or whatever.
yes. my lord.
Your lordship has not made it 4 weeks for him to
But
supply
instead of
document.
whatever order has been passed remains, except de novo.
Very- I'm very grateful. my lord.
Item number 4.
Well, I'm appearing for the respondent number 1, my lord, in this matter.
The petition is appearing in person. You are appearing, you are the petitioner? Yes. What is the matter? What is the grievance first? Tell me, what is the dispute?
So the dispute is I approached this Honorable High Court back in February of this year with a writ petition praying for direction to the Bar Council of West Bengal to act on a matter which has been pending for more than 12 months. So the single bench of Honorable Justice Moushami Bhattacharya, she passed an order on the 17th of February, asking the Bar Council to act on the matter within 3 weeks of the intimation of the order. So the order was intimated on the 23rd of February, and if I take 3 weeks from 23rd, so it's actually till the 16th March. So that is the period that they had to work, they had to act, the State Bar Council. So they actually failed to work, act on that particular time period. And accordingly, what I found out from my own research is that, they lost the jurisdiction over the matter. Why I'm saying that is because, first of all, they didn't act within the statute. The statute says, Section 35 and Section 36B of the Advocates Acts, it clearly lays down that, the State Bar Councils have to work expeditiously. The word expeditiously is used, and within 12 months.
So you have not disclosed your occupation in the affidavit. That's a mandate.
All right.
Anyway, what is your occupation?
Well,
Unemployed is also an occupation.
no, I am actually looking for an opportunity at the moment. My background is wines.
Background is?
Wine.
I couldn't get it.
WINE, wine, beverage.
Wine. Very good. You are a
Yes.
connoisseur in that.
Well, I am a wine specialist. I also
Very well, yes.
I also deal with sales and marketing. So I've
Very-
been working in the
Right.
Delhi NCR.
That's sufficient. That's sufficient.
Right.
So now you preferred a complaint before the Bar Council getting a particular advocate.
Yes, exactly.
So that they are sitting tight over that matter. Why do you say they have lost jurisdiction? Yes.
Because, my lord, I relied on judgments from the one of them is from this Honorable High Court, and I have actually mentioned that I have got the judgment with me also, and the other one is because they have been sitting on it for 12 months. The statute says that they have to work on it within 12 months. Otherwise, the matter automatically gets transferred to the Bar Council of India for adjudication. So if you consider the page number 9, paragraph 23. So I have this the observation by this Honorable High Court back in the case of Shri Bojagopal Bhattacharya versus Bar Council of West Bengal and others on 30th of August 1999. And I'm quoting, subsection 2 of section 36 clearly stipulates the withdrawal of proceedings for inquiry by the Bar Council of India from a state bar council, either on its own motion or a report of any state bar council or an application made to it by any person interested. a combined reading of section 36B(1) and subsection 2 of section 36 of the Act leaves us with no matter of doubt that once the disciplinary committee of State Bar Council lets the limitation period of 1 year expire without concluding the proceedings, it loses its jurisdiction over the matter because the proceedings stand transferred automatically to the
Chairman,
Bar
please.
Council of India
Yes.
for disposal in accordance with section 36B of the Act. In light of the stipulation contained in the subsection 1 of 36B of the Act, rather than letting that happen, the respondent number 1 passed the impugned order on 11/5/94. That order therefore clearly is without jurisdiction and in patent violation of 36B(1), section 36B(1) of the Act. Once the period of 1 year had elapsed, the State Bar Council had lost its jurisdiction over the matter, and the matter had, by operation of law, stood automatically transferred to the Bar Council of India for disposal in accordance with section 36 of the Act. It further says, point number 8, and I quote, as we have clearly indicated, on the expiry of 1 year period from the date of receipt of the complaint in terms of section 36B(1) of the Act, the proceedings stood automatically transferred to the Bar Council of India for disposal in accordance with section 36(2) of the Act. So,
Mr. Dhar, give me some dates before we proceed further.
Right.
I get your point. This
Right.
is one. What was the date of filing of your complaint?
of the original complaint,
Original complaint?
that was on the 13th of January, 2022.
Very well. And Justice Bhattacharya's order was passed on?
17th of.
Have you annexed a copy of that?
Yes.
Where is that?
Annexure number 1. So that's.
I'll just check up. Yes, 17th February, right.
That's page number 20.
Got it. Yes.
So, Milord, as you can see,
One other thing, only one last other thing. Now, where is your service of a copy of that order? Just satisfy me on that. The date of service only that. Not this. You said that you had served this order. It was to be 3 weeks from the date of service.
yes.
Have you annexed anything regarding
Yes,
that?
yes, I have.
Just show me that and give the page number.
Annexure number P2, 22 to 24, page number 22 to 24.
Very good. Yes, Mr. Dhar. What else?
So,
Got-
so
yes.
once they've lost the jurisdiction, because of the 2 reasons that I said, once they didn't comply within time of the order that was passed by this Honorable High Court,
Yes.
and losing the jurisdiction, so I automatically, I took it to the Bar Council of India as a matter of progression of the matter. So I wrote to them a detailed letter which is annexed as P3 25 to 28. If you see that letter, Milord, you will see that it's a detailed letter where I have requested them about the transfer and taking over the case because of the loss of jurisdiction of the State Bar Council. Also, because of the statute which mentions section 36B, which clearly says that they have to take over. There is no other way. And in this particular matter, what I would also like to draw your attention to is a judgment, is a landmark judgment by the Honorable Supreme Court.
It was regarding the judgment not being passed within a limited period. On that, if the judgment is not passed within a limited period,
Well,
then
now-
it has to be assigned to some other bench on that.
No, it is this particular one is a judgment wherein the chairman of the Bar Council of India,
It's a different.
the chairman of the Bar Council of India, he actually they have made an observation that he has conceded. Well, if I use a synonymous word, it's like a commitment in front of the Honorable Supreme Court. And I'm just quoting it. It's something quite important in this matter. So point
The
number,
citation, please, just give me the citation.
it's page number 12.
No, what is the judgment? I mean, is it reported
It's-
somewhere in
yes,
some journal?
It's K. Anjinappa versus KC Krishna Reddy on 17th December 2021. It's page number 12.
K. Anjinappa versus?
KC Krishna Reddy on 17th December 2021.
Yes. Paragraph number?
Paragraph number 25, page 12.
Yes.
So I'm just quoting it. It's very, very important in this matter, my lord.
May I indicate, my lord, the proposition what my learned friend is submitting,
You
my lord, is
concede.
correct. My lord, the law is now settled by the Honorable Supreme Court. If it is not decided within 1 year, by way of the section, my lord, it stands transferred, and any further proceeding is, my lord, illegal. My lord, I'll
But
cite
you are
this.
for the
I'm for the
Council
Bar
of-
Council of India, my lord, since the law has been declared by the
Have
Supreme
you
Court.
given a notice to the State Bar Council? Because they are the affected
My
party.
lord,
Yes,
that is
definitely.
so.
Yes, I have.
Just satisfy me on the service, I'll pass.
I'm yet to get it endorsed. I came this morning.
Is it good service?
The office was, yes, everything is done.
Track report you have taken?
Sorry?
You have taken a track report?
Yes, everything is attached. I came in the morning, the office was not yet open. So
Very well. I'll give you leave to file this during the course of the day. Please do that.
I'll do it as soon as possible.
As soon as possible, immediately after the order, please do that because it has opened by now.
I will
And
do that.
before recess, please try to hand it over to my officers.
Certainly will do that.
Very well. I'll give you that liberty. এটা ফেরত দিয়ে দেবো না কেউ? affirm
Would you like me to quote the chairman's commitment or?
My lord, I will
Please do
give a
that. You have to.
Yes.
My lord,
For the sake of completion of your argument.
This is very, very important because this
Have you got an extra copy of that?
extra copy of the judgment. Yes, I have got it, and
Just cite it before me. Just give a copy to me so that
I can give you both the judgments, and I've got.
I think that will be easier for me.
Yes,
I'll give
I've
this
got.
judgment, my lord, this pattern point, my lord, this covers this, my lord, it's better than.
I've
Okay, embellish my judgment
I've got it saved, so I can get it
because I
printed
have
anyway.
to actually go through the judgment. Even if you concede, cannot be a concession on law.
My lord, not, my lord, that is why, my lord, because the Supreme Court has declared the law on this, my lord. That, therefore, I cannot argue against what the proposition, what my learned friend is arguing, my lord.
Before passing this order, I have to see the law.
My lord, may I place
That
this
is where
judgment,
the-
my lord? This is a different judgment.
I'll do this. Mr. Dhar, please file your, I'll keep it as the first matter on Monday. Please file your, you don't need to do it during today. Just file your opposition when the matter is called on for hearing on Monday. I'll try to keep it at the top.
Right.
Within a few matters, if not the top matter. Just for the purpose of filing of this, and I'll pass my order. I'll go through these judgments and once check up.
So I don't need to go through this now.
No, need not read it.
Okay.
I'll have to read it
Right.
before I pass my judgment. I'll pass my orders on that date.
Right. Can I just one more thing which is very, very important
Yes.
is that I received a notification from the State Bar Council dated they sent me a letter, and
Does it say? What does it say?
yes, it actually was sent after I filed this case, so I didn't have any idea. So they said that they gist of the order, so they called for a meeting, and of course I did not attend the meetings because, as I said, I didn't want to be a party to the if I can call it the disobedience of the order. And also because they've lost the jurisdiction. So it says that above numbered case, which is 01 of 2022, case is put up before the committee for appearance and hearing of both the parties. On call, complainant is absent, which is me. Mr. Tapan Kumar Jana, advocate, opposite party is present personally along with his learned advocate. Complainant is directed to appear before this committee on 9/6/2023, which is today. And if he fails to appear before the committee on the next date, that is on 9/6/2023 at 3 p.m., then the matter will be heard in absence of the complainant and the necessary order will be passed accordingly. My lord, I just want to say something about this because, as I said, they've lost jurisdiction. They cannot adjudicate this. And the second one is, even if they pass an order and in absence.
Mr. Dhar, then I'll have to, if I hold in your favor ultimately,
Right.
then I'll have to consider this also and set aside that also. If I hold in your favor, I'll
Right.
have to set aside this subsequent order also
Right.
and relegate it to the Bar Council of India. So please, for abundant caution, then since I'm keeping it on Monday, give another notice to the State Bar Council today,
Right.
indicating that the matter has been heard and orders will be passed on Monday.
Right. I will do that.
Please do that. I'll put it in my order also.
Sure.
Mr. Kankan, if you can, please inform them also unofficially. I mean, so that they,
will try,
to
sir.
ensure
I
that they're present. If they have to say something, I'll hear them and then pass my order on Monday.
Right. Right.
Yes,
And
may I also-
just a very, very small thing is that, as per the order
Yes.
of Honorable Justice Maushami Bhattacharya, no order could be passed if the petitioner, which is me, is not heard. So it's actually says that.
No, if an opportunity of hearing is given to you, the law is that if an opportunity of hearing is given to you, that tantamounts to hearing you, if you choose not to appear. But your case is on a higher pedestal. You say that after this 12-month expiry, the jurisdiction goes.
And the non-compliance of the order.
Non-compliance is there, but jurisdiction, loss of jurisdiction is on a more sound footing.
Right.
Because if somebody doesn't have a jurisdiction, then all the subsequent orders are null and void.
Sure.
So for that, if you can, please hand over a copy of this also during the course of the day. This communication. Take out a photocopy and hand over to my officer today.
I can give it.
Or on
right-
the next day, do it.
I can give it right now.
Very well, then take it on record.
Will your lordship kindly see paragraph 28 of this judgment of the
He has
Supreme-
handed over copies.
My lord, not this one, my lord. My lord, I'm relying on a judgment, my lord.
Or different judgment.
Different judgment.
What is
my
the citation?
My lord, the citation of this judgment is, my lord. My lord, I shall also hand over a copy, my lord.
Just give me the
2007,
citation, that will do.
2017, 5 Supreme Court cases, 465.
Parties.
My lord, Ajit Singh, Arjun Singh, Gohil. I will write it down and I'll give it, my lord.
So that's sufficient.
My lord. My lord, so this, my lord, this judgment actually, my lord, takes care of all these issues, my lord. That is why I can't argue against this.
All right. Doctor.
Sorry, I have replied. Sorry, I have replied to them also, and my reply is also attached with that.
Learned the petitioner, appearing in person with leave of court, submits that in view of having sitting tight over the matter of a complaint lodged by the petitioner against a member of the bar, the State Bar Council has lost jurisdiction. First up, in support of such contention, the petitioner cites section 36 capital B of the Advocates Act, as well as 2 judgments. First up, in both the judgments, the first rendered by a division bench of this court in Brojo Gopal Bhattacharya versus Bar Council of West Bengal and others, as well as in K. Anjinappa versus K.C. Krishna Reddy of the Supreme Court, it was observed that after the expiry of the statutory period of that is 12 months.
12 months, yes.
Of 12 months, the concerned Bar Council no longer has jurisdiction to decide on a complaint, if the same has not been decided within the said period. First up, next para, it is submitted that in the present case, the complaint was lodged as long back as on January 13, 2022. First up, that apart, there was a direction by a coordinate bench of this court dated February 17, 2023, directing the State Bar Council of West Bengal to decide on the complaint within 3 weeks from the date of communication of the said order. First up, next para, the petitioner has annexed sufficient documents to the present petition to establish that the order of the coordinate bench was communicated duly at least on February 22, 2023. First up, even after the lapse of more than 3 weeks thereafter, nothing has been done by the State Bar Council. Full stop. Next para, the petitioner, comma, however, comma, adds that after filing of the writ petition, comma, the State Bar Council, which is the respondent number 2, comma, has given a notice to the petitioner indicating a further date of hearing.
My apologies. Just to make things clear, they actually called for a first meeting on the 31st of March. So that is the third meeting that they called for, actually.
A further meeting, I said.
A further meeting. So the first meeting,
Immaterial.
I have mentioned everything in the application. The first meeting was called on the 31st of March, which was 2 weeks more than the time that was given to them, 3 weeks. So the letter that I handed over
Next
to
para,
you.
it is further contended that in any event, comma, even the first meeting called after the said communication was beyond the time stipulated by the coordinate bench. Full stop. Next para. Lastly, comma, it was intimated to the petitioner that since the petitioner did not appear before the said authority, comma, in view of the pending challenge, comma, the authority had concluded the hearing and might pass orders today,
Today. Yes.
that is on June 9, 2023. Full stop. Next para. Despite service, comma, none appears for the respondent number 2 stroke State Bar Council. State Bar Council Bar Council of West Bengal. Full stop. An affidavit of service to that effect filed today by the petitioner. An affidavit to that effect shall be filed by the petitioner on the next date of hearing. Full stop. The petitioner hands over printouts, the copies of the notice issued by the State Bar Council as mentioned above, and his email reply thereto, comma, which are also kept on record. Full stop. Next para. Since the Bar Council of West Bengal chooses not to appear at the time of hearing, comma, the matter is heard expertly in the absence of the State Bar Council. Full stop. Learned Counsel for the Bar Council of India, comma, disciplinary committee, comma, submits that the stand taken by the petitioner is also corroborated by the ratio laid down in Ajit Singh's case reported at 2017 5 SCC 465. Full stop. Next para. Hence, comma, hearing in the matter is concluded. Full stop. The matter shall be listed on June 12, 2023, fairly at the top of the list for passing orders. Full stop. The petitioner shall serve a further notice on the State Bar Council of West Bengal by tomorrow, intimating the said respondent number 2 about the next returnable date, and file a receipt to that effect also on the next date of hearing. Full stop. The matter shall next be listed on June. June 12. Bas, this much. You will just give a notice, further notice, that it will be taken up on June 12th.
Can I send them an email? Is that fine? Because they have been communicating with me through emails. So
you can do that. Whatever manner, just give a notice and file something to keep on record.
Sure.
You can also send through somebody personally. I mean, you can try both ways also.
whatever your lordship wants.
I think it will be better if you try both ways.
Okay.
Because this, I don't want to keep any shade of doubt on this.
So I'll go personally to the office and hand them over a letter. So
that will be the best thing to do.
Well, they have called him at 3 p.m. today, my lord. So he can go today and serve the notice.
Yes, but
Yes, he can actually.
But they'll expect me to attend the meeting. That is the problem.
No, then go before that. Anyway, that is not an order of the court.
Right.
I'll hand over the my lord judgment, my lord. Grateful.
Grateful.
Thanks. ও হ্যান্ড ওভার করবেন জাজমেন্ট মিস্টার কানকানি, আর বাকি তো যা আছে না, এটা আমার কাছে পাঠিয়ে দেবেন। লেখছে ফরওয়ার্ডার্স করে টপ অফ দ্য লিস্টে করে দেবো। এটা আগে শুনে নিয়ে তারপর বাকিগুলো যাবে। হ্যাঁ, ওটা একটা দিয়েছি অজিত সিং কেন আমি এমনি রেফার করলাম আপনাকে, ওই একটা বলে দিয়েছি। হ্যাঁ, না হলে শুধু অজিত সিং কেস বলে ছেড়ে দিলে চলবে, রেফারেন্সটা তো দিয়েছি। গ্রেটফুল।
For hearing item number 5.
This was,
Yes,
your lordships had kept this today, my lords.
Right.
At my request, my lords.
yes, yes.
Because your lordship would find the notice inviting tender at page number 15, my lords.
Right. 15,
Is the notice inviting tender, my lords.
yes.
Because the grievance was that the tender was a closed tender. If your lordship sees at the top, it says online closed bids are hereby invited. So this was the grievance. Because I've received an email from them where looks not only they have now it's the grievance stands redressed. Because I'm seeking some directions, Mulas, from your lordships. This impanels me on their list of agencies, and this also informs me that they will permit me to participate in this tender. So in terms of this, your lordship may dispose this off. Plus one indulgence I may seek from your lordships is that after passing of this order, they may permit me certain time to submit my bid, because as on today, I only have this one page, page 15. If your lordship says this is the only thing which is available to me, I do not know the tender requirements, so I don't have the tender document also with me. So they may supply me with the tender document and permit me certain time to make my offer.
How much time will be reasonable according to you?
1 week or 10 days, my lords.
What do you say? We'll give that.
I'm very good with this, your lordship.
Thank you so much.
Because I am grateful
enough.
for keeping you so that I could come from Ahmedabad for this matter.
So my mother used to be very disappointed when her diagnostic tests showed nothing. I mean, so I don't know whether you are successful or you should be disappointed because you did not have to do much.
Because I am only grateful that I had the opportunity to come and
No, at least this has given both of us the opportunity to appear in front of your lordship.
No,
So
that is not an opportunity. Anyway, I'll pass my act order. Learned counsel for the petitioner, comma, in his usual fairness, comma, submits that during pendency of the writ petition, the cause of action on which the writ petition was taken out has become infructuous in view of a communication by the respondent authorities to the petitioner that the petitioner has been permitted to participate in the impugned tender. Full stop, next para. However, comma, learned counsel submits that due to the dearth of information and paucity of time with regard to the tender, comma, the petitioner is not in a position to submit the petitioner's bid immediately. Full stop, for such purpose, comma, the respondents be directed to serve relevant copies of the notice inviting tender and grant some time to the petitioner to submit the petitioner's bid. Full stop, next para. Learned counsel appearing for the respondent authorities, comma, also in his usual graciousness, comma, accepts such submission as reasonable. Full stop, in such view of the matter, comma, WPO 666 of 666, women
666, yeah.
666 of 2023 is disposed of by directing the respondent authorities to serve a copy of the tender document, and tender document would suffice, I suppose. You are not entitled to get anything else.
No, the tender,
Get a copy of
entire tender document.
the entire tender document along with all conditions on the petitioner within June 12, 2023, Monday. June 12, 2023, full stop. The petitioner shall, comma, thereafter, comma, latest by June 20, 2023, comma, submit the petitioner's bid with the respondent authorities. Full stop, if the bid is so submitted, comma, the respondent authorities shall proceed on the premise that the petitioner is a valid participant in the tender process and shall carry along with the tender process in due process of law, in accordance with law.
If your lordship may kindly say along.
A copy of the communication given to the petitioner handed over today be kept on record. Yes.
Along with tender document, the BOQ, the bill of quantities, that is the most important thing that your lordship may say. BOQ is very important.
It wasn't on the internet.
No, that is why we had to come here.
Since it was a closed one, so it wasn't so.
আচ্ছা একটা কাজ করে দিন, শুধু একটা জিনিস যেখানে আগে বললাম যে ডাইরেক্টেড, আমি যেখানে ডিসপোজ অফ করলাম, ইজ ডিসপোজড অফ বাই ডাইরেক্টিং দ্য রেসপন্ডেন্ট অথরিটিজ টু সার্ভ কপিজ অফ দ্য টেন্ডার ডকুমেন্ট as well as other necessary documents along with conditions, other necessary documents, whatever is necessary, please hand over so that they cannot have a
Got
further grievance on that after being resolved, the issue being
I
resolved.
will communicate with my party.
Please do that and ensure that it
Got
is
you.
done. Thank you. Please disclose to him what else you require. I mean,
Please.
if you are entitled under the law, then they'll give you.
I am grateful. My lord.
Thank you, sir.
Great for your lordship.
Original said, hey, I'll take up the appellate side matter after
Lord, for mentioning out of turn. Lord, it's an extreme urgent matter. We had mentioned it on my Lord Tuesday when your Lordship was pleased to keep it under the heading upon mentioning. It's appearing as item number 98 in your Lordship's list. My Lord, the only difficulty is, my Lord, the day when we had mentioned it, my Lord, till that day, we were informed that the letter of intent has already been issued in favor of a new contractor. Although, my Lord, I had been issued an extension thereafter. Now, my Lord, on the very same day when we mentioned before your Lordship during the pendency of this, my Lord, writ petition, my Lord, the BHEL had now issued, my Lord.
Upgradation I'm not allowing because most of the matters are extremely urgent. If I go on taking upgraded matters, then the regular matters.
My Lord, the only difficulty is, my Lord, they have now issued letter of termination to me, my Lord, on the date of mentioning itself, when, my Lord, this entire thing was pending.
Yes, right now I cannot. I cannot upgrade. I'll take up in due course serially. I'll take up the
My
matters.
Lord, if some precedence, my Lord, may be
No,
given
I'm
a
sorry.
lot.
No, apart from upgradation, if you have to mention anything else, you can mention.
May be permitted to mention for inclusion in the list, my Lord,
Apart from upgradation and inclusion.
the matter was fixed to appear on 8 June by Honorable Justice Mousumi Bhattacharya when he is.
8 June,
eh,
fixed
she-
date taken.
She was, while she was having the determination, but it was not.
No, if that direction was given, it should appear. Hand over.
Analogous.
The list. Yes, very. Call on the list. Call.
Appellate side, item number 1.
My lord, item number 1, my lord, Mr. Mohim Shashmal appearing for the petitioner, my lord. He's suffering for high fever, my lord.
When should I keep it?
My lord, I'm paying for not today only, as per the direction.
On the prayer of the petitioner, the matter is urgent for the day.
My lord, one small submission.
Yes,
It's
yes.
the fourth day, the same submission is being made.
My lord, I am just instructed.
And on the last day also, yesterday they made
And
the
my
same
lord, if your
submission.
lordship kindly allow
Let
me.
us come back. Please remind me, Mr. Nayak, on the next date. If
My
he
lord, I
doesn't-
have the
It's a
exception, my
matter
lord.
for filing, my lord, exception to
Call
all.
on the next
My
matter.
lord, I have the exception, my lord. If your lordship directs me, I will file.
Should
my
have
lord.
filed it. No. Come back on Monday.
My lord,
Yes.
deeply obliged.
Get full.
Item 2.
I appear on behalf of the CSC in this matter.
Oh, that
Respondent number 4. I have taken instruction, my lord. First of all, my lord, this is a block meter which has been applied for. My lord, we kindly come to their writ petition, my lord. The page 29,
Who has applied for block?
The
The
tenant.
petitioner.
the tenant. The petitioner tenant. Kindly come to page 29.
What is the difficulty in giving Mr. Mukherjee?
My
Straight
lord,
up to the point.
my lord, I have filed a report, my lord. My lord, what has
Tell me what
happened?
is the crux of your
My lord,
report so
this
that
is
we
in
can dispose of
respect
the
of-
matter now.
This
Yes.
is in respect of 14 and 14/2 Guho Road. My lord, 14 Guho Road.
I'm
my
fed
lord,
up with Guho Road, Mr. Mukherjee. How can a connection be given to
my
them?
lord, connection can be given, my lord, through this, through by a news service, my lord. In 14/2 Guho Road, my lord. Where
Give them the liberty, they'll apply by tomorrow and you give the
the only
satisfaction.
thing, my lord, the objector, my lord, should give us relief in respect of laying out the cable.
What the objectors?
The erstwhile landlord, Suren Bosak, the respondent number 4.
For the respondent number.
They cannot have any objection. They are saying
My lord, what has happened, my lord? The 14 Guoro is one premises. Subsequently, part of the premises has been transferred in.
You will be giving a service connection at 14/2 for
yes.
user at 14/2.
Yes.
I'll make an order of the court so that they can't.
But my lord,
obstruct.
there is one more thing, my lord. The owner of 14/2 Guho Road is, my lord, now the respondent number 5.
5 and 6.
My lord, there is an application for block meter. And it will be better, my lord, if the owner applies, because, my lord, there is
No,
no.
they will not apply.
Well,
He will apply. He will apply. But why block meter? Block meter can be given to him also.
Yes.
Because
Because
an individual it can be given.
yes, they have applied Vijay Kumar Pandey and 10 others. Kindly see page 29.
10 others.
Who are the 10 others? Inter family or inter neighborhood or what?
No, it was.
Who are the 10 others? You
My
cannot give
page
position to 10 others.
29.
No. Since it was applied.
I'll
only-
give him liberty, Mr. Mukherjee, to apply for a single service connection, which he will give in their name, in his name, the tenant's name. And if one service connection is given, I'll make it a part of my order so that you can give the connection without any hindrance from either of them.
But my lord, we have to lay cable.
Yes.
We have to lay cable from 14 because this is one premises.
Underground.
Yes. My lord, they have to give us the way leave. My lord, it will not. It will.
I'll give you the way leave.
Malar OLIF, to the extent of OLIF, Malar this sketch map is already with me. And in
You
that
did not give
process,
any
Malar, that
weekly,
can be
I'll
done.
give them the value. Yes, what do you say?
Milord, as I had said, Milord, just the ingress and egress of 14/2, Milord, which is through a passage, shall not be disturbed wherever the
I'll
meter
put
can
that
be.
in my order.
Yes, Milord. And one extra, Milord. He is allegedly the tenant, Milord. There's a title suit pending, Milord.
Oh, yes,
Kindly
it is.
that
No,
defense.
that
so
I'll clarify.
it
That
should
I'll-
not.
Yes, what is your objection?
Malar, my objection is that OLIF is already there, so Malar, they cannot, Malar, use my land. The 14 land cannot be used.
Underground connection will be taken from wherever it is
Malar,
existing.
Malar, that is, that
Your
will be
underground is not your ownership.
No, that will
That
difficult.
is the
Malar,
CSC Limited's ownership.
that can be, Malar, they can draw that, Malar, on the passage which the using by the tenant. Right now, they can, Malar,
I'll override that
well,
objection.
kindly consider the, kindly
That
one
considered,
thing, man,
considered.
one thing, man.
No.
Malar, later on, Malar, they can, Malar, claim for, Malar, easementary right. The owner-
Underground, are they moles or rats? They'll claim underground easement right.
Malar, the,
Electricity company already has a line. They have given connection to
they can
you.
say the line has been drawn already by the electricity authority. The
It is
telephone
there
line-
for you. Your connection has been given from there.
No, my connection from the municipal road to that, my 14. But that
But,
is,
Malar,
the OLIF is already there. There is a common passage that.
Learned Council
that-
is not a person.
The last
I'll see nothing else. Ashwin. Learned Council for the CSC Limited, comma on instruction, comma submits that the CSC Limited has no objection on principle to give a new service connection at premises number 14/2 for the user of the occupant of 14/2. Full stop, next para. Learned Council for the respondent numbers 5 and 6 submits that such connection ought to be given at such a location of premises number 14/2, which will not disturb the smooth ingress and egress of the respondent numbers 5 and 6, who are the owners of the premises. Full stop, next para. Learned Council appearing for the respondent number 4, comma, who are the primary objectors, comma, submits that the connection be given to the petitioner at 14/2 independently without disrupting the possession of the respondent number 4 in any manner. Full stop, next para. However, comma, the CSC Limited is of the opinion that underground cables have to be laid, may have to be laid at premises number 14. That's 14.
Yes, the service is already there on 14. We will take the.
Premises number 14, comma, where a service is already existing, comma, for the purpose of enabling the CSC Limited to give the new service connection to the petitioner at 14/2. Full stop, next para. It also transpires that a civil suit is pending between the private parties. Full stop, next para. In view of the above submissions, comma, it cannot be gainsaid that the petitioner, comma, under section 43 of the Electricity Act 2003, comma, has an indefeasible right to get electricity connection as an occupant of premises number 14/2. Full stop. Although the petitioner claims to be a tenant thereof, comma, which is disputed by respondent numbers 5 and 6, comma, such issue is not germane for the purpose of giving an electricity connection to the petitioner, comma, since, comma, in any event, comma, the said question will be decided in the pending civil suit between the parties. Full stop. Be that as it may, comma, WPA 8262 of 2023 is disposed of by granting liberty to the petitioner to apply within a week for a fresh service connection at premises number 14/2, comma, Guho Road, comma, Kolkata. Full stop. If such an application, Howrah. Oh, sorry, not Kolkata, Howrah.
We will cancel the block meter application which they.
Full stop, next para. If such an application is made, comma, the CSC Limited shall process the said application and for such purpose, comma, may deem the prior application for block meter connection of the petitioner to stand cancelled. Full stop, next para. Upon such processing as necessary, comma, the CAC Limited shall, comma, within a week of the application, comma, raise due estimate and serve the same on the petitioner. Full stop, upon the petitioner complying with all formalities and depositing the requisite costs, comma, the CAC Limited shall, comma, within 4 weeks thereafter, comma, lay the necessary connection and give a new service connection to the petitioner.
Lay cables,
আমি কি বললাম, lay the
necessary connection.
lay the necessary cables and give a new service connection to the petitioner at premises number 14/2. Full stop. However, comma, while giving such service connection, comma, the CAC Limited shall be careful not to disturb the smooth ingress and egress of the respondent numbers 5 and 6 stroke owners to the said premises, that is premises number 14/2. Full stop. That apart, comma, it is further clarified that such electricity connection, comma, if given, comma, shall not create any special right or equity in favor of the petitioner, which the petitioner does not otherwise have in law. Full stop. In the event the CAC personnel are obstructed in any manner in doing so, comma, it will be open to the CAC personnel to
Respondent number 3.
approach the respondent number 3, comma, that is the officer in charge of the Belur police station for police assistance. Full stop. The respondent number 3 shall act on such communication and or a server copy of this order and give such assistance at the cost of the petitioner for the purpose of enabling the CAC personnel to lay such cables where necessary and give the new service connection to the petitioner. Full stop. No orders to cause urgency.
My lord, deeply obliged, my lord. Just one indulgence, if I can pray, my lord. In the second paragraph, your lordship had stated that in 14/2, the connection to be granted, my lord, they are, according to instructions which I have received, my lord, they are under possession of a tile shed, my lord. If the meter board, if at all, could be placed in the tile shed, if your lordship deems fit.
Won't introduce any further.
Subject to compliance of all formalities, we will lay cable from 14 and give it to 14/2.
I shall.
Whatever.
Deeply
Yes.
I'm grateful, ma'am.
Thanks. Call up.
Item 3.
3, yes. Which is pending.
I'm from the WBCC.
The petitioner.
What is the matter?
My lord, petitioner is the permissive possessor.
You have
And-
served properly on the private respondent.
Only three chairmen has refused to accept it.
No, 3. The private respondent 7,
I will
6,
say,
7.
yes, always,
7. Yes. What is the matter?
petitioners and pro forma event, they are the son and mother. They are the permissive possessor. And 5, 6, 7 are the next door neighbor, and they have no title.
Who gave permission to whom for the possession? You are the occupier.
I am the permissive possessor, yes.
That's very good. Your mother gave you the permission.
Mother given, and there is no objection from the mother.
5, 6, and 7 are neighbors. What do they say?
They say they the electricity board, they went and to give the connections, but objection raised by the 5, 6, 7, and they have not given the connections.
That means, any written objection given by them?
No written objection.
Achha, what is the premise of their objection?
My lord, as per their statement, my lord,
Yes.
they are the sole occupier. They are the sole occupier of the entire premises. As per lease deed was executed by the son of the original owner. That is, original owner was Harangi Pasi, and son is the name Ramakant Pasi. And according to that lease deed, they are the sole occupier. And
The petitioner has produced any document to show their possession?
Yes, my lord.
They did not
My lord,
produce us any
kindly
documents.
come to P1.
And one civil suit is, my lord, pending, and it is sub judice.
Why did you suppress the civil suit?
My lord, civil suit page number, my lord, kindly come to page number P3, page number 19.
Who filed the suit against whom?
My lord, I file against the 5, 6, 7.
You did not file. Your mother filed.
Mother.
For eviction?
For declaration and permanent injunction. And there, 5, 6, 7 not appeared. That's why expertise dismissed. Why expertise dismissed?
But dismiss, why you're saying dismiss softly?
Because I have
But
filed,
your suit has been dismissed
yes,
then.
my suit. Because I have also filed that SRO report, that is P1. There they said we are the permissive possessor over there.
No. Your suit was for declaration and confirmation of right title, not only right title interest, but also possession.
Yes, ma'am.
That suit stands dismissed.
Dismissed.
If that has been dismissed, then not dismissed I mean dismissed for default.
No.
So if it is dismissed, your right has been negated. How can that right be, that possession be created in your favor?
According to the report of subdivision LR and LRO, that is P1, that says that yes, it is Pasi is the title, but that after demise, they are in possession.
Who are in possession?
Respond number, petition number 1 and 2, and pro forma defendant. Kindly come to P1, my lord. That in reference to your letter dated 21/2004, this is to inform you that as per RS ROR, the plot number 172232 clarifies as Bastu, having an area 0.12 acres, has in favor of Harangi Pasi, son of
no, Mr. Ghosh, you are not entitled to get electricity. Your position has been disbelieved by the civil court. Have you preferred any appeal against that?
No appeal. But my lord, electricity,
right.
My lord, that is it is the electricity.
You are not in settled occupation. Even electricity has to be given to a settled occupier. You're trying to create a position where there is no position. I'm sorry, no. Learned counsel for the petitioner argues that the petitioner is in occupation of the property as a permissive occupier under his mother, comma, the pro forma respondent number 8. Full stop, next para. However, comma, the respondent numbers 5 to 7, comma, who are neighbors, comma, are objecting to the electricity connection being given to the petitioner at the premises in question. Full stop, next para. Learned counsel appearing for the WBACDCL submits that an objection has been raised by the private respondent numbers 5 to 7 on the premise that the said respondents are in possession of the property by virtue of a lease deed, and the petitioner is not in occupation of the property at all. Full stop. Insofar as the petitioner is concerned, comma, no proof of possession has been produced before the WBACDCL. Full stop. Next para. Learned counsel for the WBACDCL further points out that a civil suit was filed by the pro forma respondent number 8. Full stop. Next para. Upon being inquired, comma, it is revealed by learned counsel for the petitioner that the title suit bearing title suit number 168 of 2003, comma, a copy of the plaint of which has been annexed to the writ petition, comma, was filed by the mother of the petitioner and once Sri Chaudhuri. Full stop. Next para. However, comma, it has been admitted in the writ petition that the said suit was dismissed by the civil court on March 5, 2019, holding inter alia that the plaintiffs failed to establish title over the suit property and nothing to show the actual possession of the plaintiff over the suit property. Full stop. Next para. Hence, comma, since the petitioner claims possession through pro forma respondent number 8, comma, whose suit was dismissed inter alia on the finding that the pro forma respondent is not in possession of the property, comma, it cannot be said under any stretch of imagination that the petitioner is in settled occupation of the property. Full stop. Next para. The mere communication by the
Senior revenue officer
by the senior revenue officer
two in charge.
in charge of the office of the SDL and LRO, Asansol, cannot create a right or position in favor of the petitioner in the teeth of the dismissal of the suit of the pro forma respondent number 8 as indicated above. Full stop. Next para. Hence, the petitioner has no locus standi to apply for an electricity connection, not being in settled occupation of the property. Full stop. As such, WPA 11891 of 2023 is dismissed without any orders to cost. Sorry, Mr. House. Next. Sanjay Ghosh Gupara, দিয়ে দাও।
Item 4.
My lord, I appear for the state.
Oh, state.
And for the petitioner, my lord, this is regarding this procedure A and procedure B applied. We have
Yes,
applied for procedure A. My lord, WBSCDL have give the report.
Yes, they don't have to pay the entire expenses. Which particular provision?
My lord is pleased to.
Please use the microphone. Please use the microphone. Mr. Rai.
My lord is pleased to turn to page 3. My lord, I only have provided a lordship for the privity, only the relevant portion.
Yes, yes.
My lord, clause 6. Well,
So 6 is regarding when there is a turnkey project.
no, my lord, other than the turnkey project also. Turnkey
Also,
is on, in clause 4, my lord.
Now, how do you know his proportion before there is any other consumer? This is the first person who is applying for that.
Yes, my lord.
Now, then
Lord,
he has to pay the entire connection charges. Subsequently, when probably there is a provision for refund if there are other applicants.
my lord, if I may take your lordship.
Yes,
to the-
please read it out.
Yes, my lord. No, my lord, if my lord is pleased to turn to page 2, the erstwhile page, my lord.
Page 2, yes.
My lord, recovery of reasonable expenditures for providing new connection.
Right.
Yes. Where the distribution means already exists in the vicinity, the costs of service line measuring up to 30.48, that is 100 feet, from the tee off in section points, but not failing on the premises of the consumer, including the cost of installation shall be borne by the licensee. My lord, I believe this is what I have been made to understand, that there is something which can provide within this.
No, you are,
provision. So 100
he is
up to
within
100
this.
Yeah, up to 100 feet.
No, his case is within this.
My lord, there is some other connection close by. So
So you can accommodate that.
that is what I have been made to understand, your lordship.
So he doesn't have to pay anything extra.
No, nothing extra. He will have to pay his portion, his proportionate share.
How will the proportion be? Acha,
That will be calculated.
from the existing connection.
Yes. Your lordship.
Then it's over. What is the role of the state in this?
My lord, we
Creating
have nothing.
trouble. If there is no trouble, you have to create trouble.
No, my lord, we are not creating anything.
Not creating. Learned counsel for the WBSCDCL hands over a printout of a notification of a notification dated April 2, 2013, being number 53 of the WBERC, known as the WBERC within bracket recovery of expenditure for providing new connections bracket closed regulations, 2013. Full stop. It is stipulated in the said notification, in the said regulations, that the licensee shall bear the costs of giving supply of electricity for a new connection if the distribution mains already exist in the vicinity and the applicant has to bear only the applicant's proportionate share of the expenses. Full stop. Next para, it is submitted on instruction by the WBSEDCL that, comma, in the case of the petitioner, comma, there are pre-existing distribution mains in the vicinity and, comma, as such, comma, the petitioner is required only to pay her proportion of the expenses. Full stop. Next para. In such view, comma, the petitioner does not have any further impediment in bearing extra costs if the petitioner applies under Form Pro B 2010. Full stop. Next para. Accordingly, WPA 11893 of 2023 is disposed of. You have not filed under B.
No, we have 500.
I'll give you the liberty. Disposed of by granting liberty to the petitioner to apply for the new electricity connection in her premises by way of form number PRO B, capital B, 2010, within a week from date. Full stop. Upon such application, comma, the WBSEDCL shall duly raise estimates for the expenses to be paid by the petitioner, comma, calculating the same on the basis of the proportional share of the petitioner only. Such estimate shall be raised within a week from the filing of such application and handed over to the petitioner. Full stop. Thereafter, the petitioner shall comply with the requisite formalities and make the due payments. Full stop. The WBSEDCL shall, comma, within a week after, within a fortnight after such compliance of formalities, comma, give the new connection to the petitioner. Full stop. No address to cause urgency.
Item 5.
Pore file ta ready rakho. Yes, Mr. Shen, you were for the state.
State, Lord, but I was requesting a lordship to Lord accommodate me for 1 day, Lord.
So, come back to
Tuesday then.
Yes. Very well. Tuesday, all right. For on the prayer of learned senior counsel appearing for the state respondents, the matter is adjourned and shall next be listed on June 13, 2023.
Item 6.
My lord, I am the petitioner. My lord. There's an analogous matter along with this which has not appeared. That was also supposed to be.
Give the number, I'll take it up together with the other matter.
My
Give the number, both will appear together on matter.
deep.
কোনো অর্ডার রেকর্ড করতে হবে না, নট টুডে করে রেখে দাও আর গিভ দ্য নাম্বার আদার নাম্বার
My lord, I am giving the number.
ওটার সঙ্গে এটা থেকে
Deep.
থ্যাংক
Item 7.
Yes, what is the matter?
The private respondents doesn't seems to be delivered, my lord. Kindly keeps it not to dates only, my lord.
Not today will do, or I'll keep it some other I mean after some time.
In
Do
the
we are
next-
on 9th.
Ah.
Should I keep it on 16th?
My lord.
Since the private respondent has not yet been served properly, comma, let the matter stand adjourned till June 16, 2023.
Grateful, my lord.
Item 8.
I'm for the petition.
Yes, Mr. Mitra.
My lord, on
Lord,
fourth,
I may indicate, Lord, I am here only because I've been made a party. The principal respondent is the West Bengal
Respondent number 2.
Transport Corporation.
respondent number 2. Yes.
They are not represented. You are appearing for them. You are appearing for the respondent number 2.
Yes, yes.
Well, yes, Mr.
Now, my lord, on 4th of March 2022, my lord, notice inviting tender was issued by the respondent number 2 for, my lord, setting up, my lord, several way bridges. My lord, those are required, my lord, for diverse reasons, my lord. Supreme Court has also said that, my lord, those are required. Now, that was done, my client participated. It was initially, my lord, when the technical bid was opened, my lord, it was my client was there. Thereafter, my lord, they cancel, my lord. But before that, my lord, I will show your lordship some of the provisions of, my lord, the NIT, my lord. My lord, kindly come to, my lord, page 31. 32, kindly come.
Yes.
Name of the work. The government of West Bengal in the transport department has taken the policy to set up motor vehicle way bridges, hereinafter called such and such, at the border with the neighboring state for intercepting both incoming and outgoing vehicles to and from the state, and even intrastate, with the object of collecting due tax and fees as per provision, detecting overloading, then C, detecting other offences committed under relevant tax and rules and realizing fines, issuing permit to incoming transport in exercise of the power conferred under rule such and such. Now, my lord, kindly see, my lord, the last, my lord, it is, my lord, signed by the managing director of WBI TIDC, my lord, with the, my lord. Now, my lord, if your lordship is pleased to come to, my lord, page 34.
Yes.
Instructions to bidder. Kindly come at the bottom, my lord, date and time schedule. Particulars, kindly turn the page. Clause 6, my lord, date of opening of technical proposal 28 March 2022. And then 7, date of opening of financial bid to be notified later. Next, clause 8 is important. Clause 5 is important, my lord. So it possibly ought to have been 8, but be that as it may. Clause 5.
Yes, right. Wrongly repeated again.
Yes.
Anyway, the second 5.
Second 5. The Managing Director, West Bengal Transport Infrastructure Development Corporation Limited, reserves the right to cancel the NIT due to unavoidable circumstances, not generally. And no claim in this respect will be entered. So, my lord, if there was some unavoidable circumstances, yes, it can be cancelled. Then, my lord, kindly come to, my lord, some more clauses, my lord. Kindly come to page 37.
Yes.
Bidding process, Roman 2, technical bid. Clause D, details of land in possession of title, leasehold, lease control at given location, if any, is to be given with necessary supporting documents. I will tell your lordship, my lord, the requirement was, my lord, a certain, my lord, size of land with a frontage on national highway or state highway at the given location. And, my lord, the land has to be on both the sides.
Of the border. Of the border.
Of the road.
Of the road. Achha.
Yes. So that, my lord, incoming and outgoing vehicles possibly, my lord,
Both
that's
ways,
why,
yes.
my lord, that is the requirement. Now, my lord, this, my lord, tender process was cancelled on 2nd of May, 2022. And, my lord, immediately thereafter, my lord, a fresh tender on same terms were issued. Now, cancellation, kindly come to, my lord, page 54 once. Towards the bottom, my lord, the second part.
No reason given, cancelled.
Yes, cancelled. And not by the not under the signature of the managing director. If your lordship is pleased to come back to that clause, my lord, once, page 35. The Managing Director, West Bengal Transport Infrastructure Development Corporation, reserves the right to cancel the NIT due to unavoidable circumstances, etc. P is the ballot issuing authority. Now, on 3rd of June 2022, my lord, a fresh tender was issued, or notice inviting tender was issued on the same terms and conditions. My lord, identical, I'm not placing that document. Same terms. Now, my lord, my client participated. If your lordship is pleased to come to page 101. Lordship will find, my lord, the second part of it, 22nd June 2022.
Yes.
It is informed that your bid number has been successfully submitted on such and such. There are 4 bids, my lord, because 4 locations were there. Now, my lord, after that, my lord, my technical bid was accepted. My lord, if Lordship will kindly come to, my lord, page 105, my lord.
Yes.
105, my lord, Lordship will find 3, my lord, bidders. My client is the first one.
Right. There is no Bisho before that.
No, fortunate. No. And my lord, this was also communicated to me, my lord. Kindly come to page 113.
113. Yes, Mr. Mitra.
You were informed that your bid for the above tender has been accepted during technical evaluation by the duly constituted committee, etc. Now, my lord, our instruction or the petitioner's, my lord, information was that the financial bid was also open, but they did not have any clue. Suddenly, again, my lord, this tender was cancelled.
Third.
Second, the second tender, this was cancelled.
This was cancelled.
Now, kindly come to, my lord, page 116.
Yes.
After the line, my lord, the above mentioned e-tender has been cancelled due to administrative reasons.
Here also MD clause and that clause was there. Same.
Identical. Now kindly turn the page, my lord, 117. It is informed that the tender has been cancelled. You may kindly visit the portal for further details. Well, nothing was available in the portal. Representations were made. No response. Thereafter, my lord, an application under RTI was made. Kindly come to the response or to the RTI, my lord. Kindly come to page 129.
Yes.
Kindly come to, my lord, query number 2. Please inform if the subject tender has been cancelled. Yes, the subject tender has been cancelled. Then 3. If the answer to query number 2 is in the affirmative, please provide me reasons for the same. The tender has been cancelled due to inadequate confirmatory documents submitted by the bidder.
Achha.
Now, my lord, if that was so, the technical bid could not have been accepted.
Unless they mean something else by confirmatory. There is no provision in the NIT regarding some further confirmation. Very good. So you are challenging this cancellation.
My lord, I am not going into the question of law, my lord. Firstly, my lord, there is another clause, my lord. I'm sorry. I ought to have pointed it out, my lord. Page 35, I had shown your lordship.
Yes.
And there is another clause, page 41. Page 41, my lord, A7.
A7 is rejection of.
The tender inviting authority reserves the right to accept or reject any bid and or cancel the bidding process and reject all bids at any time prior to the award of contract without thereby incurring any liability to the affected bidders or any obligation to inform the affected bidder or bidder on the ground of such action from tender inviting authority. My lord, I have twofold submissions to. Firstly, my lord, if there are 2 clauses in one document, the earlier clause has to prevail. And here, my lord, the clause at page 35 has to prevail. Our court has also
35, is it mutually exclusive from 41, page 41? Because this is rejection of an individual bid.
Yes.
And the other one is the entire tender process is cancelled. So two operate in different contexts.
But both have to be, my lord, in any event, both have to be read harmoniously, my lord. Merely, my lord, saying that, no, I cannot do this. My lord will
So
not.
your bid was never rejected by them.
No.
That was never rejected. If it was rejected, they might have said something else. But your bid was not rejected, but the entire process was cancelled. And when you ask for the reason, they say that confirmatory documents, lack of confirmatory documents, on which they did not reject the tender, the bid.
That
Bid.
was not disclosed, my lord.
That was not disclosed at least. Very.
Now, my lord, in that view of the matter, my lord, this rejection, my lord, the last rejection, my lord, in my full submission cannot stand. Lord,
Yes.
those are my.
Yes, please take your seat. Yes.
But
What
so
is
far as, my lord, the matter is concerned, my lord, today I am only, my lord, submitting before lordships on the point of, my lord, the interim order, if any, there is scope. Since, my lord, the half an hour ago, my lord, I received the brief, my lord, I am yet to receive the written instruction from my client. But only to place before lordship, my lord, that page 35, page 41, these may not be relevant at this point, my lord, since this was the earlier tender floated in the March.
No, the same terms are repeated.
Yes, that is there. So same terms in the next tender documents that can be referred, my lord. So my lord, the tender floated in March 2022 and cancelled in April 2022 may not be relevant for the present moment before a lot.
For the purpose of the clause.
Yes. So,
and your conduct, your cancelling time and again.
Yes,
maybe that also.
So my lord, the page 74 is the same thing, my lord, rightly pointed out by my lord senior friend, that the same terms and conditions is
What is
there.
the defense?
My defense is, first of all, my lord, we have
No defense.
Lord, first of all, my lord, everything has been, my lord, done in the month of, my lord, June 2022, cancelled in July 2022. So, my lord, at the present moment, after 1 year, June 2023, my lord, nothing, my lord, so urgent that any scope of any interim order is there, my lord, number one. Number two, my lord, is specifically stated that the authority has every right to cancel the NIT at any point of time, my lord. That right is reserved, my lord, with us. And in several occasions, my lord, there are several judgments also.
So,
my lord,
Mr. Mitra has placed that unavoidable circumstances clause.
Yes, my lord. The
So there
administrative.
has to be a specific unavoidable circumstance. So
that I will.
Inexpediency probably that has also, and you have stated inadequate confirmatory documents submitted. This is
But that I will certainly deal in my affidavit, my lord. That I will certainly.
Have you issued a new tender after this?
No, not yet.
So don't do that. That much restraint I'll pass on you. Stay of this does not mean anything.
Sorry, my lord, what I forgot to point out, my lord, is that, my lord, on the basis of, though possibly no right accrues, but still, on the basis of the requirement, my lord, my client also procured lands on both the sides.
Well, that I am disputing, my lord.
No,
So,
definitely,
my lord,
that has been given.
That has to
that
be taken
is
into
the, my lord, precondition of a tender, my lord. It is not possible that after floating the tender, my lord, my client, my lord, provided opportunity them that this time I am providing you procure land and then bid. Now, that is perhaps not possible, my lord. Those who have those lands already, my lord, they can only bid, my lord. So, my lord, this point, my lord, may not be maintainable, my lord. And so far as what fell from your losses, my lord, that is not the prayer, my lord.
No, in a sense, estoppel.
No, that is not the prayer, my lord. So, my lord, we have right, my lord, that has to be, my lord, ascertain, my lord, that whether we have right or not, my lord. So, my lord, no interim order, no prayer for interim order at all is there, my lord, specific prayer, my lord. If your lordships kindly see the prayers, my lord. All the prayers are in final in nature, my lord, if your lordships allow them. So, my lord, let us, my lord, come back with affidavit, my lord, at the present moment.
Ad interim terms, G.
Yes, that I have seen, my lord. But even if in any ad interim prayer, if your lordship is passed in respect of any prayers, those who are all are in final in nature will be. No specific interim order is there, my lord. That if any subsequent bid should not be published by the authority or something like that, that is not there in the writ petition.
But if
so far as I have gone
fresh,
in the last half an hour.
You're right. If you issue a fresh tender, then it will be difficult. Then this challenge will become infructuous. Don't do that. How long will you take to file an affidavit in opposition?
2 weeks, lordship.
2 weeks. Thank you. Mr. Mitra, I'll pass that order only. They'll not issue. Learned senior counsel appearing for the petitioner has urged certain alleged irregularities and illegalities in the impugned action of the respondent authorities in cancelling a tender, where the petitioners participated and the technical bid of the petitioners was accepted. Full stop. It is contended that initially a similar tender was floated but subsequently cancelled. Full stop. Even the second tender which was floated and in which the petitioners participated, comma, contains similar clauses, comma, one of which was that the same can only be cancelled under unavoidable circumstances, comma, that too by the managing director, comma, West Bengal Transport Infrastructure Development Corporation Limited. Full stop. However, comma, the second tender was subsequently cancelled without giving any plausible reason for doing so. Full stop. It is further submitted that the person who issued the notice of cancellation did not have locus standi to do so. Full stop. That apart, comma, it is argued by the petitioners that when the petitioners made a query under the Right to Information Act as to the reason of the cancellation of the tender process, comma, the information afforded by the respondent authorities was that the tender has been cancelled due to, within double inverted, inadequate confirmatory documents submitted by the bidder. Double inverted close, stop. Full stop. However, comma, there was no such allegation at any point of time, comma, nor was the bid of the petitioner cancelled, but the same was accepted at the technical stage. Full stop. Next para, learned counsel appearing for the respondent authority submits that since the impugned cancellation took place sometime last year, comma, there is no compelling urgency for passing any interim order at the present stage. Full stop. It is further submitted that the tender issuing authority reserves the right to cancel a tender at any point of time. Full stop. Next para. That apart, comma, learned counsel for the respondents also refutes the contention of the petitioners that the petitioners have already invested huge amounts and purchased lands in terms of the notice inviting tender by arguing that the same was the prerogative of the petitioners and not the lookout of the respondents. Full stop. Be that as it may, comma, in view of the prayer for filing affidavits, comma, the respondents are directed to file their affidavits by June 23, 2023. Full stop. Reply, if any, shall be filed by June 30, 2023. Full stop. The matter shall be listed for hearing on in the monthly list of July 2023. Full stop. The respondents shall be restrained by an order of injunction from issuing a fresh tender, a further fresh tender for the same work as covered by the tender which was cancelled by the impugned decision till July 31, 2023 or until further order, whichever is earlier.
But after 1 year of passing this cancellation, my lord, this restraint.
After 1 year, if you have not issued any tender,
yes, that is always there, my lord. So, my lord, this prayer, my lord, kindly record one thing, my lord.
the full stop, it is made clear that all questions are kept open, including the objection of the respondent authorities as to the alleged inordinate delay in filing the writ petition. That will cover every delay. Anything else?
No, my lord, there was no prayer for any. My lord, the order your lordship has been passed, my lord, that was not been prayed by my land.
That sort of made a wider prayer.
This is, my lord, this interim order, my lord, fell from your lordship, we shall certainly abide by. But this has not been prayed before lordship.
Made a wider prayer.
Yes.
Item 9.
9. For a file, ready. Yes, 9. Who is for the petitioner? You cannot reach the court.
Reach the court, my lord, could not reach it.
Literally. Yes. What is the matter?
My lord, the affidavit of service, my lord.
All served. Mr. Mukherjee, you are for the licensee or what is this?
Distribution company.
My lord, the private respondent, my lord, is drawing electric connection.
Put service on private respondent.
My lord, may I, my
Check
lord,
up. That is important. If you open with the private respondent, it has to be good service.
Certainly. Yes, my lord. Good service.
Good service.
My lord, the private respondent has drawn an electric connection, my lord, over the land of the petitioner, my lord. The difficulty is, my lord, the connection is not, my lord, a regular connection. It's not a regular connection, my lord. They have just drawn a line, and my lord, electric sparks are happening, my lord. I made some complaint, and inspection has been, my lord, made. My lord, kindly comes to page 44. That's the inspection report, my lord. The situation, my lord, will be, my lord, crystal clear from this report, my lord.
Yes.
But one consumer, namely Dheeraj Kumar Shaha, the petitioner here in my lord, bearing consumer number such and such, submitted a grievance to this CCC where he mentioned that one death trap was created by electric wire, which is used by Dheeraj Kumar Shaha. After that, one physical inspection was done by this office, where it was detected that this electric wire is not a service cable of Ashish Shaduka, my lord, that is the private respondent. That is, this PVC cable was not drawn by WBC SCDCL for the connection of Ashish Shaduka. The PVC cable is connected to the main switch of Ashish Shaduka, and it provides electricity to a temple.
That is pilferage.
That is
It's why don't you take steps? Because it's a temple.
No. But PVC line, we have no way. This is a private arrangement between this person. We can't do this because distribution company is only.
So you are selective in choosing private arrangements which are pilferage and unauthorized.
No,
if
but
a temple is using Osit's connection, it's unauthorized use.
But according to him, Osit is doing the same. Now,
not according to him, your report. This PVC cable is connected to the main switch
of Dheeraj,
Osit Sadhukan, and it provides the electricity to a temple. If it does,
according to my instruction, I cannot go beyond that. My
cannot go beyond this, Mr. Mukherjee.
But
How do
I
you
have seen
this.
I have seen this. Now, if your lordship see once, one PVC line, one connection has been taken. Now, we have intimated the Shaduka. Now, what is the case of the petitioner? That he purchased the property from.
Mr. Mukherjee will take steps against Sadhuka for unauthorized use. Within a week, you will file a report on that.
Then, before that, then kindly give, because that prayer which is showing, today morning I just received from the mail. Now, kindly.
That cannot be an excuse.
But I have to take instruction to
That's
that.
your client's latches.
I have to take instruction to that because
you don't need to take instruction. It is clear in. Come to page 44, Mr. Mukherjee. How do you overcome this last sentence of the first paragraph?
That I have seen, my lord. That I have seen that
Read it out then once. If you have seen it, you have not digested yet. Read it out.
Ashish Shaduka is requested that please dismantle or ship the PVC cable from the premises of Dheeraj Kumar Shah. Dheeraj Kumar Shah. Dheeraj Kumar Shah is the petitioner before your lordship.
Obviously.
Now, my lord, what is the case, my lord? If you lordship see once, my lord, only for 1 minute.
Mr. Mukherjee, it's your option. Either I seek a report as to what steps you have taken for this unauthorized use, admitted unauthorized use, or I can give you the liberty to take steps and come back with a report immediately.
Then kindly keep it 10 days time. I will, the second one which is fallen from your lordship, my lord, because my lord, your lordship is of the opinion, my lord, that when we have already issued this letter, now, my lord, the thing is that, my lord, this is absolutely.
If you are the judge, Mr. Mukherjee, what opinion you do of me? What other opinion is possible from this? If you admit in a communication, this PVC cable is connected to the main switch of Asit Sadhuka. PVC switch the connection goes over Dheeraj's property. Connection given to Asit. This PVC cable is connected to the main switch of Asit, and it provides electricity to a temple. So Asit has not applied for electricity for the temple, neither has Dheeraj.
But if you
what is this?
If you lordship see once, my lord, the agreement between the petitioner and Asit. But if you lordship give me 1 minute time. But what happened, my lord? That the petitioner purchased the property, a part of the property from the brother of the Asit. There is an agreement between the petitioner and the Asit that, my lord, the Asit will maintain the temple, and, my lord, for that petitioner, and anything wrong is done, that will be responsible by the Asit. And the petitioner says that in his writ petition that it was done 2 years back, and he lodged complaint before the police authority and the municipal authority. Now, my lord, what we have found, but I found this letter is say that this is illegal. Now, my lord, kindly visualize, my lord, absolutely private dispute between the parties. Now, my lord, what Asit is doing, Asit is taking the connection from his own meter to the temple. And if you lordship see once annexure P2, that is the agreement between the petitioner and the Asit. If you lordship see once regarding the temple, my lord, once, or the paragraph he has also stated, my lord. If your lordship see once his petition, your lordship will find, my lord.
Give me the page.
Paragraph 3, my lord.
Yes.
Your petitioner states that on the date of registration of the said property, the petitioner also entered into a notary agreement with the brother of his vendor, namely Oshit Sadhuka, son of late Kanailal Sadhuka, in respect of Kali Mandir, which is standing in the purchase property of the petitioner. And in the said agreement, said Oshit Sadhuka agreed to look after the said Kali Mandir and to bear all expenses of the said Mandir, including the worship of idol. It was further agreed that for any illegal activity, Oshit Sadhuka will be sole responsible for that, and the petitioner would be responsible for that. Then, my lord, kindly see that for that, and the petitioner would not be responsible. Then, my lord, kindly see, your petitioner states that the private respondent is very much greedy person and taking advantage of the absence of the petitioner. The private respondent heavily damaged the wall of the said mandir and drawn unauthorized electric connection to the mandir over the main entrance of the petitioner's house without the permission of the petitioner. And when the petitioner, after returning his house, noticed about the fact, he asked the private respondent to repair the said damaged wall of the said mandir and also to remove the unauthorized electric connection over the main entrance of the petitioner's building. This is the main grievance of the petitioner, which may cause accident anytime, but the private respondent refused to pay any heed to the request of the petitioner. Now, your petitioner states that when the petitioner understood that the private respondent will not pay any heed to the petitioner's request, the petitioner, getting no other alternative, made a complaint before the concerned inspector in charge, Titiagoda police station. But this is a complaint and regarding the police. Now, this has been done 2 years back. Now, my lord, one day, my lord, we found lock and key. That's why we have sent the, but what he is alleging that we also cannot take the meter reading. That is for, I have taken the, by telephonic instruction, one day meter was lock and key. The room was. Now, my submission before your lordship, my lord, that absolutely, my lord, private dispute between the parties. The PVC line has been gone. But this letter of the distribution company, my lord, that, my lord, that the temple has, according to their own agreement, temple has to be maintained by Oshit. Now, my lord, for the temple, Oshit has taken a connection. I am not supporting the Oshit or anyone. Now, if your lordship direct, my lord, we will definitely take steps in terms of
Oshit to take the connection to give to the temple.
Yes,
to give electricity to the temple.
Yes.
The connection was in the name of Oshit.
Oshit. Kindly see his own statement. Kindly see once, my lord, the paragraph.
That is a private agreement between the private parties.
Private party.
You are not bound by that.
Absolutely.
You are bound by the law. You are a distribution licensee. If there is an unauthorized use, if Oshit took the connection for the specific purpose of the temple, then it's a different aspect altogether.
But that I have to take instruction whether Oshit has been taken connection for the temple, because that, my lord, I need to take instruction, my lord.
Mr. Rai, I'll direct affidavits to be filed in this matter.
Sir, one thing, it is in such a condition, my lord.
No, the difficulty is they are saying that it is within your premises. It is not within their domain. It is not outside the premises or not their lookout. I mean, it's an electricity dispute undoubtedly, but if it is within the premises of Dhiraj and an illegal whatever PVC pipe is there, then it's your lookout to take appropriate steps.
Yes, that's why, my lord. What he has done, my lord, he has drawn his this line.
That is your relief against Oshit. Ask Oshit to make it to mend it.
We have made that this connection was taken from the main gate of my entrance, and that is caused.
That connection goes through your property,
over my property,
over or through.
Over.
If the WBSEDCL washes its hands, they say they have not given this connection, so they're not responsible. So you take your steps, private steps. What steps? Tell me.
I asked the police to cut down the electricity. I approached the authority.
That's a private dispute. Approach the appropriate authority.
My lord, can you consider this is the dispute? What is the dispute? It is maintaining the temple. It is not within my land. The temple is within Oshit.
You agreed to permit him to do so. Take the connection for the temple.
Yeah, you will not.
You admitted in your agreement.
My lord, can you turn to my agreement? I have annexed. It is not P2. P2.
Your paragraph 3 says so.
Yes, P2, my lord. Can you consider P2, the agreement?
Yes. You take your recourse under the law against Oshit then.
Then, my lord, can you consider this is the electricity line which was taken unauthorizedly by Oshit over through my property to give electricity to another premises, meaning the temple. Even if, my lord, I am maintaining the property, whether I am giving authorization to maintain the property or not, something.
He is the owner of the temple.
I'm not the owner of the agreement. Probably my learned friend did not go through the agreement or the deed which
Get time to, because it was given to him last night. probably.
because deed is not with him, so otherwise you could have.
And he has other matters also.
Yes. Such a busy council, I need not to disturb him, my lord.
তো লাইভ চলছে কিন্তু
No, Mr. Rai, only one thing.
এতক্ষণে my lord kindly consider, এতক্ষণে প্রথম পক্ষের উক্ত শপথে একটি কালী মন্দির রয়ে আছে। So প্রথম পক্ষ is my lord is
এতক্ষণে or এক্ষণে?
ধীরাজ।
এতক্ষণে আর এক্ষণে এতক্ষণে
না
is a different expression.
প্রথমে এক্ষণে এতক্ষণ
এতক্ষণে was in your mind.
এটি কালী মন্দির রয়ে আছে, উক্ত কালী মন্দিরের
Mr. Rai, let us not be on this. You have agreed with the private respondent that this connection will be given to the Kali temple. Now you resign and say, yes, connection has been given. That is as per your agreement that you state in your writ petition. But now what is happening is there are safety hazards. Safety hazards, they say, are pertaining to the PVC connection going through your property, which was not their doing. So it has been done by somebody else, probably, Ashit. So you take your remedies before the civil court or whichever other. If you are a tenant, you can go before the controller also. You know the remedy.
If your lordship can kindly consider my agreement, what my learned friend is saying regarding the
No, your paragraph 3 plus
yes, my lord,
5
kindly
first
consider
read it
paragraph
first.
3 once, my lord.
Yes.
Once. A notary agreement with the brother of the vendor, namely Shri Ashit Sadhu, son of the Kali Mandir, which is standing on the purchase property of the petitioner. And the said agreement, it will look after the said Kali Mandir and to bear all expenses. There is only for the purpose of maintaining that Kali Mandir. It further agreed that not any illegal activity Ashit Sadhu will be sole responsible for the, and for that petitioner would not be responsible for that. That is within my premises. I said I'll maintain
That's
it.
a private dispute then.
Yes, but the electricity line which can be laid down or to taken in such a condition that is safety measures, and the authority himself saying yes, it is a safety concern. In spite of that, whether my lord, I have to go through.
Mr. Rai, if they take steps, then it's your connection. From your main seat has been taken over your property.
Over my property. So over my property.
Private dispute, Mr.
My lord, kindly
For a
consider.
change, Mr. Mukherjee is right.
My lord, kindly consider there is safety hazards. It is the authority who himself saying it is a safety hazard. So my lord, I am using electricity in such a fashion which is caused safety hazard to somebody else. And he has to file a suit for the purpose of restraining the say. It is the authority who is responsible. He is saying that yes, what you are doing is wrong.
Very well. They'll hold an inspection. The petitioner has.
But only one thing kindly visualize. But what Mr. Rai is saying, what he is saying that his property has been damaged. But whether
I'm not damaging portion. I am
kindly see the prayer of the petition.
The petitioner has canvassed before this court that the private respondent Ashit Sadhu Khan had entered into an agreement with the petitioner undertaking to maintain a temple situated on the purchased property of the petitioner. Full stop. However, even as per the said agreement, the liability for any illegal activities would be the responsibility of the private respondent and not the petitioner. Full stop. Subsequently, it is contended, an electricity connection has been taken from the mains of the said private respondent and has been connected to the temple in question.
No, but kindly see the inspection reports that says otherwise.
Full stop. Next para. It is further argued that even as per the inspection report dated September 9, 2020 of the WBACDCL, it is clear that one consumer, namely the petitioner, it is clear that the WBACDCL detected that the electric wire in question was not a service cable of Ashit Sadhu Khan, within bracket private respondent bracket closed. That is, the PVC cable was not drawn by the WBACDCL for the connection of Ashit Sadhu Khan. Full stop. The PVC cable, it was mentioned in the report, is connected to the main switch of Osit Sadhu Khan and it provides electricity to a temple. Full stop, next para. It is further disclosed in the report that Osit Sadhu Khan was purportedly requested by the WBSCDCL to dismantle or shift the PVC cable from the premises of Dhiraj Kumar Saha. Full stop, next para. Surprisingly, although such inspection report is of the year 2020, till date, there is nothing on record to indicate that the WBSCDCL has taken any steps for such apparently unauthorized use of electricity from the main switch of Osit Sadhu Khan. Full stop, that apart, although the WBSCDCL seeks to avoid liability for any hazard, if so happens, on the ground that the PVC cable runs through the property of the petitioner and was not connected by the WBSCDCL, the inaction on the part of the WBSCDCL in not taking any steps for such hazardous, unauthorized use of electricity might very well be construed as negligence of the WBSCDCL, which could lead to fire hazards. Full stop. In such view of the matter, the WBSCDCL is directed to hold an inspection with prior notice to the petitioner and the private respondent Osit Kumar Sadhu Khan to ascertain the threat perception with regard to the PVC cable in question. Full stop. The WBSCDCL shall also ascertain as to whether the drawing of the said connection to a temple from the main switch of Osit Sadhu Khan tantamounts to unauthorized use within the contemplation of section 126 of the Electricity Act 2003. Full stop. A report in that regard shall be filed by the WBSCDCL on the next returnable date, that is on June 20, 2023, when the matter shall next be listed for hearing. Full stop. Give a report that will disclose everything.
Item 10.
My lord, I am for the petitioner, my lord.
What is the matter?
I have served, my lord. My lord, petitioner before your lordship is a
Please use the microphone just.
petitioner before your lordships is an unfortunate mother, my lord. Her minor girl was kidnapped by the private respondent number 8. And after complaining before the police, my lord, police recovered the girl on March 2023. And
What is the age of the child?
14, my lord.
Yes.
And my lord, they handed over before the home of CWC. CWC, my lord, home, my lord, that is respondent number 5. My lord, they are not giving my daughter, my lord, to me in spite of repeated request, my lord. My daughter is crying, my lord, and mother is trying
This is covered by the Juvenile Justice Act.
Yes, my lord, CWC Act. Child.
Let me hear Mr. Shen on that. Yes, Mr. Shen, what is the provision if there is a family?
My lord,
you have to restore the
my lord,
child.
may I tell? My lord,
Yes.
the child, my lord, was missing, or went missing in, my lord, Haryana, Gurgaon. Now, my lord, there, my lord, the police lodged the complaint and the FIR at paragraph number 6 in the petition itself.
Yes.
Now, my lord, what happened? But ultimately or eventually the child, my lord, was recovered in West Bengal.
She went missing in Haryana?
In Haryana. When her, my lord, parents were there.
Achha.
I mean, it is mentioned there.
Yes, yes.
Ever mentioned there.
She was recovered in West Bengal.
Recovered in West Bengal, but the complaint lodged there and the police case filed there. Now, my lord, the CWC repeatedly asked the Haryana police where the complaint has been lodged and the case diary, my lord, started, that to come down here, now take custody of the child and complete the formalities for handing over the same to the parents. Some formalities are to be followed therein. Now, my lord, they replied to CWC that they would come very soon and they would take back the child there for the purpose of completion of formalities.
What is the provision of the statute Do you require their
But since, my lord, the case has been lodged therein, so they have to take, and according to what my instruction is, my lord, that they have to take their custody first, and parents should go there and complete the formalities. And
No, my lord.
this is, I am told, my lord, by the
which
CWC.
provision, which is the
Then,
relevant?
my lord, if that is so, then, my lord, kindly take it in the next week. In, my lord, I shall, my lord, because whatever my instruction over phone.
Parents are without the child, child is.
Yes, my lord, we are also.
Parents live in West Bengal, my lord.
After
We
this
also,
trauma, Mr. Sen, you can very well appreciate.
my lord, yes. We also want to, my lord, that the child be
No,
immediately
definitely,
hand over to the
My lord,
parents.
parents live in West Bengal, my lord.
Yes,
They went there
There is
for
no dispute regarding that.
livelihood, my lord.
Acha, but one thing,
My lord.
should I direct him to impede the Haryana police also for abundant caution?
Should
First,
be.
satisfy me, Mr. Sen, on the law.
Yes.
If I see that there is any scope of directing you to hand over or give visitation, then I'll do that without the Haryana police.
The whole thing is this,
Yes.
that in the midst of this, because unless there was any, my lord, the complaint lodged before the Haryana police station and the FIR therein, so that, but because if CWC, my lord, hand over the child, then, my lord, that police case would remain
No, I'll
pending
look
therein.
into the provisions of the law,
That
Mr.
should
Sen.
be.
I'll look into the provisions of the law only to see whether the court can do that, whether or the permission or whatever from the Haryana police is a mandatory requirement. I mean, Haryana police, whether they can withhold this permission or whatever language you use, whether they can do that. If they can't do, if it's not mandatory, then I'll put in something in my order so that they can visit their child at least, or some visitation right or something.
Whatever.
But if it is not permitted by the statute, then I'll not violate the statute.
Whatever the order comes from your lordship, my
No,
lord,
no,
we have
that is
to
not
follow.
law. I have
Because
to go
after
by the
all,
law.
it's a 14-year child, my lord. She should, my lord.
No, I'll
get-
first
get
have to,
back to
please go
her
through the
parents.
statute, Mr. Sen, once. Please satisfy me on that it's a mandate of the statute that the Haryana police have to either give some communication or whatever. If there is no mandate, I'll permit. If there is any mandate, then I'll direct them to be implemented and direct them to.
Then I have to, my lord, go through the relevant provisions of the relevant statute, and my
I'll
lord,
also go through the. I'll try to go through the statute.
uh,
All of us, let us go through the statute. So for this child, yes.
My lord, in the meantime, my lord, they are
In the meantime, before
they are
Monday,
trying to send their, my lord, home, my lord. These home
No,
is
no.
the culprit, my lord. My lord, last occasion, one order has
where
been
is the
passed.
child now?
Home,
At the-
Digambarpur,
at,
South
my
24
lord,
Parganas, my lord, respondent.
Your
Respondent
appendix should be
number
moved from there.
Yes, my lord.
No, you'll not do that, Mr. Sen. Yes.
No, I do not, I have no instruction, my lord.
Learned counsel
is
for
his
the petitioner
submission.
contents that you are the mother.
Yes, my lord.
Learned counsel for the petitioner contents that the petitioner is the unfortunate mother of a minor girl of about 14 years age, who went missing and was subsequently found. Footstep. Thereafter, the Child Welfare Committee of West Bengal, within bracket CWC, has retained the custody of the child with a particular home where the child is not being able to meet her parents. Footstep. Next para. It is submitted that in such view of the matter, the custody of the child may be handed over to the petitioner. Footstep. Next para. Learned counsel appearing for the respondent authority submits that the child was recovered in Gurugram, Haryana.
No.
Police station,
Child,
Gurugram,
child
Haryana.
went missing there.
That the child went missing in Gurugram, Haryana, but was recovered in West Bengal.
Yes.
Full stop. As such, it is submitted that what would you like to put it as? Consent of the Haryana police or communication by the Haryana police?
My lord, the Haryana police has to, my lord, take custody of the child for the completion of the formalities.
Very well. যেখানটা ছাড়লাম সেখানটা
hand over the child to her
Haryana
parents.
police is required to take custody of the child and thereafter to hand over custody to the parent in terms of the law. Full stop. Next para. Learned counsel for the respondent authorities is requested to satisfy the court prima facie as to such requirement in the statute book. Full stop. For such purpose, the matter is
Kindly, my lord,
Tuesday.
Kindly, my lord, indicate that with regard to the release of the child, the any further involvement of Haryana police is required or not? Lordship, kindly.
Whatever it be. For such purpose, the matter is adjourned till June 13, 2023, when it will next be listed. Come back, Mr. Shen, I'll consider everything. Every aspect of
My lord, at the same
Next
position.
date, Lordship. কবে?
13th.
My lord, at the same position, my lord. My lord, otherwise, my lord, there is no interim
Same
order.
position, how can it assure same position?
My lord,
These are ridiculous
my lord,
submissions.
if they handed over before the Haryana.
Item number 10. No, may not be same position.
No,
You
Mala,
yourself will come.
I shall Mala, communicate that even if they come, not to. Mala, kindly, Mala, keep it on 14th. Lordship.
No, 13th. 13th is sufficient.
This is complete, my lord, kindly be paying.
Not complete.
Not complete, my lord.
On the prayer of the petitioner, the matter is adjourned till when?
Not 1 week's time. my lord.
Till June 16, 2023.
12.
Your lordship, I am for the petitioner. The service is not complete. Kindly adjourn it for a
Actually
week.
not complete, or you're taking?
No, your lordship, it is not complete. Actually, lordship, it was
16th?
filed on the 19th, because of which
No, very
vacations.
Till 16th, I'm adjourned. The same order again.
Item 13.
If it pleases your lordships, my lord, I beg to appear for the petitioner, my lord.
Yes.
The service is complete, my lord, and my learned senior,
My lord, I am appearing for the state, my lord.
learned
I'm not-
friends were here, but now I
Lord.
think they are yet to come. So, my lord,
In any circumstances, my lord, I will be praying for an accommodation because my instructions from the state respondents are yet to come, my lord. My lord, on Tuesday, my lord, on
On Monday, come back on.
I am for the Milord of
Yes. No, this is an electricity matter.
yes, my lord, this is an electricity.
Your lordship has already passed in one matter.
This
we
is an
have-
Is the
electricity.
state required to furnish anything?
Since, no, my lord, only thing is that there may be a district magistrate's report may be required for this.
No, my lord,
property.
I tell your
If
lordship.
they can,
Acha, very well. Let us see if
I
it is not possible. I'll definitely.
I tell your lordship, my lord, already matter has already been referred to the district magistrate under the Oxford licenses rules by us, our station manager, because there is an objection by the Dulagarh truck terminals. The district magistrate, I am told on 25th, last hearing was take place,
yes, my lord.
25th May.
May.
So, my lord, district magistrate is in the section of the matter, my larger clients, and all of them participated. All of them,
The private respondent.
all of them were participated in the, before the district magistrate.
So what is the present in this in the connection
yes.
with this matter, that direction was given?
Yes, in this.
if your lordship so
No, lordship's direction is other matter.
Other matter. So why is this matter similar matter?
May I place my
Similar.
case, my lord?
Let him
Yes.
place his case. Yes.
I'm so grateful, my lord.
It is it possible to take up without or the state has a role to play?
All, no, state,
Since the matter is.
primary responding.
Let's see if it is not necessary, then why?
My lord, my affidavit of-
Yes.
My lord, this has got some checkered history, my lord. Fortunately for all of us, my lord, this checkered history runs through the documents in the form of order and judgment of this honorable court, my lord. If your lordship may be pleased to take up page 32 annexure P3, my lord.
Yes.
My lord, this is an order passed by your lordship on 21st of February 2022 in the first round of litigation, my lord. This is the 5th round of litigation. In the first round of litigation on this order, my lord, if your lordship takes a internal page 2 running page 33, my lord, and lordship may kindly take note of the submissions that has been duly recorded by your lordship, which was made on behalf of private respondent number 9, who is also private respondent number 9 before your lordship in this case. Lordship would
No,
make
in
this,
this matter, state has no role to play. Are you sure?
my lord.
No, yes, state has role to play because the district magistrate, total district magistrate.
Then
the
I'll
matter is
adjourn the matter
subject
till
to the-
one day. Let her
before
take
the district
instruction, come back.
magistrate.
Yes, my lord,
My
because
lord,
instructions.
my
are
primary,
required.
yes, my primary allegations are against, my lord, the private respondents and WBSCDCL, my lord. If your lordship allows me to place the case, my lord, lordship will.
No use allowing you to place the entire case, then granting them time, because the state is asking for time. One day adjourn to take instruction. Let them take instruction. Come back on Monday.
Then, my lord, can it be on Tuesday?
Tuesday.
Tuesday, my lord.
Tuesday, definitely, yes. An adjournment is sought by the state. Full stop. Let the matter stand adjourned till June 13, 2023. Come back on that.
I'm grateful.
So let us have a comprehensive hearing once and for all, instead of coming back piecemeal.
My lord, my
No,
lord.
yes,
So
yes,
grateful, my
because
lord.
the matter is pending before the district magistrate.
Maybe because that there is a role to play, probably. There may be a role to play.
We have already installed 8 poles. Further 11 poles are required to be installed for the purpose of giving connection all the owners. That's the main issues. And the Duragarh truck terminals are raising objections saying that this land is belong to us. That's
Let them place their case before
Yes.
you start, Mr. Kole.
I'm so grateful.
grateful.
14.
Yes. You are appearing?
No, I would
You are not appearing.
This is pitching.
Oh, Mr. Mujumdar is there. Yes.
I appear for the respond number 1.
Acha. Who is for the petitioner? Anyway, I'm adjourning for the day.
Yes.
None appears for the petitioner, although the respondent number 1 is represented through counsel. Let them attest and adjourn
This has
till
to be decided on affidavits in any way. My claim of more than an 11-year-old
any
claim.
scope of interim order, Mr.
No. I tell you, Lordship, what is the issue? The issue is that there was a contract, a works contract.
Huh.
The works contract, my lord, was closed sometime in the year 2010. My lord, they did not pay any service tax. As a result whereof, they did not claim any service tax from us.
Mr. Majumdar, because they have stayed, they have prayed for stay of operation of impugned memo, whatever may be that,
I do not know my lord, what memo they have.
whatever that may mean, and they have also asked for.
But that is the
forthwith
memo that
reimbursement.
we will not pay. That we will not pay. That is the memo.
That is to be stayed, and forthwith reimbursement has is to be direct.
That is the final relief.
Let him come.
Very well, my lord. I will.
So if even if I refuse that, I mean, I'll have to.
Yes, my lord.
None appears for the petitioner, although the respondent number 1 is represented through counsel. Accordingly, let them attest and adjourn for the day.
For the day, my lord, kindly keep it on Wednesday, subject to lordship.
Wednesday, definitely. Let them attest and adjourn till June 14, 2023.
Great.
Thank you.
15.
Mr. Naik is for the WBC DCL, my lord. Only short pass over, my lord.
Mr. You are for the state. Yes, let us hear the matter. Mr. Naik.
Short pass over, my lord.
You are sufficiently competent. No, it's high time you move this.
No, my lord, I have no instruction that wise.
So what?
Well,
It's a
only
dispute
short
related.
pass over. He is on
Can
break,
we
my
come
lord.
to page 25? It was an order passed by your lordship. My lord, here, your lordship, my lord, an unfortunate incident happened. One person died due to the electrocution. Then, my lord, the wife of the deceased came to your lordship and asked for compensation. Then, my lord, your lordship directed the DM to, my lord, the take of the matter and to, my lord, decided the compensation to be granted or not. My lord, kindly come to page 27, last but one paragraph. Your lordship it is clear to your lordship's order that whether WBCDCL is having any liability or not, that to be assessed by the district magistrate. Now, what district magistrate had did, my lord, the compensation was imposed upon a private person. That he cannot. My lord, so, my lord, challenging that order, that is at page 30, I came up before your lordship. Now, my lord, two things, my lord, your lordship's order was never to decide the private question. DM is not the authority to decide that.
You are the private party.
Yes, I am the private party. And thirdly, my lord, I am facing a criminal trial, and the criminal court, if I found guilty, then, my lord, compensation will be imposed under the victim.
That was pending prior to this district magistrate order.
Yes.
Who are you?
My lord, I am the private persons against whom a criminal case.
Who are you? I mean, how are you involved in the
My
matter?
lord, according to their allegation, a cable connections was overhead in the my lord, pole. My lord, during the accident, my lord, they are saying that some GI cable of the cable caused the death. My lord, what I am on is that, my lord, that dispute cannot be hesitated by the DM.
Let me hear the state first then. Yes, Mr. De. Please give him the microphone, Mr.
This order is explicitly clear. They were directed to decide. Kindly see, my lord, at page 26.
Yes.
Last paragraph. Accordingly, such and such writ petition is disposed of by directing respondent number 7, that is the district magistrate Bankura, to decide the dispute regarding the liability for payment of compensation for the death of electrocution of the petitioner's deceased husband, and upon giving adequate hearing to all the concerned, to come to the conclusion on the basis of the inquiry on or materials as deemed necessary.
Next line is missing, probably.
Next line is missing.
Missing.
Thereafter, the district magistrate shall communicate her decision to the petitioner and the concerned parties. This is the order. Hearing was given to all the parties.
Paragraph.
Next paragraph, you want I should place, I am placing. There is no difficulty. The court has not gone into the merits of the dispute between the West Bengal State Electricity Distribution Company Limited and the petitioner regarding such liability and or your lordship has not gone into, nothing is there. Now that upon inquiry, my lord, I have got the papers. Upon inquiry, my lord, it was found that cable operators, two cable operators were operating, and they kept the cables which snapped. Resultant effect is the, my lord, accident. And the district magistrate thereby has, my lord, directed to pay 5 lakhs. What is the wrong in the order? I fail to understand.
Mr. The liability was directed to be fixed undoubtedly. Now liability has been fixed. Suppose it is held that these people have liability.
Yes, they are responsible.
But whether they can be directed to pay compensation is it within the domain of the district magistrate?
No, it is under the order of the court.
The order of the court was to fix the liability. I'm telling you, as you placed. The direction was to decide the dispute regarding the liability for payment of compensation for the death by electrocution of the petitioner's deceased husband. Now, these people, were they given a hearing?
Yes.
Against whom the liability?
Yes.
Or they were given a notice and
Yes,
hearing?
yes.
And may I answer to this?
No, I'll come to you. Please take your seat and let him finish. But Mr. Even if the liability is directed to, let us see the input order once. Let us come to that. Whether compensation can be directed because the district magistrate under the relevant acts, the Works of Licenses Rules and Electricity Act, as well as Telegraph Act.
I understand what is playing in the mind of the court.
Whether that was beyond the jurisdiction. Liability, he has said, his report is yes, liability is
If
fixed.
the person who are responsible for the accident, as to whether I am raising a question as to whether the district magistrate can direct them to pay apart from what is there in the act.
There is the district magistrate is not empowered under any statute to do that, to saddle liability on a third person.
I have said, my lord, by the order of the court as per direction of the court.
Order of the court was not to fix compensation or to pass direction. The order of the court was by directing the respondent of 7, that is the district magistrate Bakura, to decide the dispute regarding the liability. And the liability was never, the dispute in the writ petition was between the writ petitioner and the WBSEDCL.
State is nowhere.
No, state is nowhere. And these private respondents, they were private respondents in the writ petition also, probably not.
Yes.
They were not parties.
No, they were not parties.
They were not parties there. So these are third parties to the writ petition. In that dispute, the writ petition, it is directed, respondent number 7, district magistrate, to decide dispute regarding liability for payment of compensation for death of electrocution of the petitioner's deceased husband. Very well, it has been done. This compensation portion is what is pinching them actually.
Compensation is 5 lakhs.
To be borne by both the parties, lordship. I beg to excuse me, lord, to enter my appearance.
Borne by both the parties means?
Both the cable operators, lord, accused, because the petitioners here in the matter.
5 lakh distributed between the two.
So far as my understanding is concerned, lordship.
5 lakh and 5 lakh.
This is nothing.
May I say
And it is not maintainable ipso facto on the face of it, lordship.
Why?
Because my lord's order was there. District magistrate is to take into the matter to go into all this. A district magistrate, after examining as many as about 27 witnesses and considering their statements and considering other factors, also has come to the conclusion these two petitioners, they have all along, they are the cable operator operating in the area, and without taking permission of the board, they are handling the cases, and they have somehow connected, drawn their wiring by touching the high tension line, which is having no concern for all these reasons. And the high tension line has got their cable operation, this cable line has been charged by that.
The writ petitioner has been served. The original writ petitioner has been served. Are the parties here?
Yes, perhaps respondent number 8 or something.
Respondent number 8.
8
have been served properly. Check up the.
Respondent number 8.
And district magistrate has passed a very reasonable order, complied all corners. Where is the flaw? They have not stated anywhere why it is they can challenge.
Malan, may I say one thing?
Mr. Can I keep this on record? The documents you handed over? Yes. Please take your seats, both of you, Mr. Naik and Mr. Dey. I'll just share with you.
Over to Mr.
What is that?
The report that I have handed over to the communication. Private.
Item delivered to DM article room, article receipt room. Oh, address is also there. You're right. Very well. Yes. What is the difference to this?
My
5 lakh 2 cable operators. It was directed. You should have challenged my order, then challenge my order in appeal.
No, my lord, what I'm on is,
yes,
my lord, against me, a charge sheet has been filed where an 304 has been alleged against me. My lord,
that is independent of this.
My lord,
that
I
has
am
no
facing
connection with
the trial. Now, if I give the compensation and it will be accepted by me that the cable, they are saying that that was there. My defense is that it is the electric, WBC DSCL's thing that
This will be without prejudice to your rights in the criminal case.
what
I'll clarify that.
secondly, the DM do not have the authority to that, and your lordship's order also didn't say so, because the last but one paragraph, your lordship says this court has not gone into the merits of the dispute between WBC DCL and the petitioner regarding such liability and quantum of the compensation while passing this order. So it was between, if your lordships, the entire order is placed before your lordship.
The day labor 5 lakh has been given. You are the cable operators in the area. Yes, I appreciate your agony, your apprehension that this might worsen your case in the criminal matter. That I'll take care of.
Kindly, do one thing, my lord. If I'm lordship, kindly clear that if I am found guilty in that criminal trial, then my lord, the criminal court itself is supposed to give the compensation under the Victims Compensations Act. So my lord, if I am not guilty, my lord, because my lord, my defense will go, because my defense is that the GITR they are calling, my lord, it is, my lord, kindly come to page 28 for once. My lord, cable goes through the optical fiber cable. My lord, it is, my lord, through this, my lord, electrocution cannot happen scientifically. So my lord, I said before the DM that even if it is, my lord, during the incident something had happened, my lord, that will not electrocute any person.
But you submitted to the jurisdiction of the district magistrate. You had the proceeding contested entirely. After that, after getting the order, how can you resile from that position?
My lord, question of liability will not come because the DM do not have the authority. The DM do not have.
You did not take the point of authority before the DM at any point of time. You participated and submitted to the jurisdiction of the DM.
So, my lord, this question has. What happened?
Yes.
Kindly see the order of the DM. Last 2 paragraphs. Last 3 paragraphs. Peruse the statement of Jugal Banerjee, proprietor of Asa Cables, and Sheikh Safiul Islam, proprietor of Star Internet and Cable. Both the proprietors have clearly confessed.
So from where are you reading, Mr. Dey?
Yes, sir. Order under challenge.
DM's report, Lord. So DM's order.
What is the page number?
That is
I was
page 30.
30.
30.
Not 30. In fact,
30. 30, but
yes,
it cannot, it is not
right.
readable at all.
Yes, peruse the statement. I've got that.
Your lordship has got from the.
Got it. Peruse the statement. Yes.
Peruse the statement of Jugal Banerjee, proprietor of Asa Cable, and Sheikh Safiul Islam, proprietor of Star Electric Internet Cable and Cable. Both the proprietors have clearly confessed that they are running their business through fitting cable wire with West Bengal State Electricity Distribution Companies Limited code or 3 as available, and they do not get any commission from any authority. As such, they did not apply for permission to the distribution company for the installation of the cable wire distribution company electric code. They also stated that cable wire, which is used for TV and internet services, is called OFC, optical fiber cable, and strongly demanded that the material by which the OFC is produced is not electric conductor, and there is no possibility of electronic. But report received from the video, Kotulpur says that the local people operator, cable operator also use uninsulated GI wire which came in contact with the electric line of the West Bengal State Electricity Distribution Company Limited and caused the accident. After this, my lord, if this amount has been fixed, I don't think, my lord, any wrong has been committed. And my lord, your lordship's direction was not under any act to decide. This is a social offense.
In fact, the Electricity Act has no provision regarding compensation. This modality is not provided. That is why the district magistrate was directed. Very well, I get your point, Mr. No interference, sir. Pay that amount and I'll keep this without prejudice to your rights and without prejudice to the writ petitioner in the other, claimant of the compensation, without prejudice to her rights to claim more compensation before the civil court.
When the wife of the deceased came before your lordship, there was no allegation by the wife of the deceased against me.
Need not.
My lord, she had the allegation against the WBCDCL because she had the knowledge that we are not the guilt person.
True.
Now, my lord, it has been shifted to us. My lord, my defense is very categorical that the optical fiber cannot run electricity. My lord, that is the specific defense in my lord, the criminal case I am facing. There, my lord, no GI my lord, cord was seized. My lord, now suddenly, my lord, that is the best defense I can take there. Now, my lord, if DM decided that the cause of death is due to the GI, then my lord, it will, my lord, completely prejudice my lord, the legal defense in the criminal trial. Now, my lord, what I'm on, my lord, let there be a compensation. Lordship may give that indication, but only after I been proved the guilty, because that will always be in the mind of the judge that by the order of the High Court and this and that happened, thereafter compensation.
What is the
was
stage
given.
of the criminal proceeding?
My lord, it is charge sheet submitted. My lord, lordship may expedite everything. My lord, that is my specific defense. If, my lord, I found guilty, then, my lord, I will pay the compensation.
Man will die by this time.
Because of you, it has died. You have shifted the burden to me. You have said unscientific words.
Should I give an indication? These are also in our area. Everybody's area.
Mr. On the merits, there is very little scope for them to argue. I mean, against this order. Although in the criminal case, they may have a good case. But Mr. The only thing is, even if the court directed whether the magistrate had the jurisdiction. Although I am the court which directed, but even then, fixation of liability in a dispute between the WBSCDCL and this claimant, that very well may be directed to the district magistrate. There is nothing in the statute. Actually, the purpose was not to relegate to the complainant to the.
Your lordship has given reasons why your lordship is relegating it to the DDS.
There is no trapping in the act. Nothing in the.
Kindly see your lordship's own order. Your lordship wanted to save the family.
My lord, kindly see the paragraph 3 of the stand of the WBCDCL in the earlier writ petition. My lord, paragraph 3.
The remedy of the petitioner would ordinarily be before
Yes,
the
right.
court. After being the court was conscious of, still then your lordship directed, and I tell your lordship, if your lordship sees in naked eye from your rooftop, it is abutting to the road. The cables are drawn, taking assistance of the GI wires. Cables will fall otherwise. Cables are tied with GI rope. You can correct me if I am wrong.
Yes, but my lord, it is non-continuous. It is non-continuous, so my lord, it will.
Very well, I'll pass my order right now.
My lord, only one small submission, sir, I make. My submission is this, my lord. No, not me against. At page 26 of my lord's order, my lord, all these views have been, my lord, expressed. My lord, last paragraph, page 26 of my lord's order. Accordingly, WPN number so it is disposed of by directing the respondent number 7, that the district magistrate Bankura to decide the dispute regarding the liability for payment of compensation for the date of the electrocution of the petitioner's deceased husband, and upon giving adequate hearing to all concerned and to come to a conclusion on the basis of the inquiry or materials as deemed necessary, and thereafter district magistrate shall communicate this order. Now, my lord, charge sheet have been filed. Here, my lord, 22% have deposed.
Charge sheet is in a different proceeding.
Yes, yes.
Criminal proceeding that which was
Now,
initiated
only
prior
one,
to this.
161 statements, what I say, my lord, 161 statements can reveal can give some light on the facts of the case. So 22%, most of them are the relatives of the persons. And my lord, they have also deposed. And all they say,
This cannot have been an adjudication under the Criminal Procedure Code. This was pursuant to the direction of court passed in a writ petition that has been done.
Lordship.
This cannot prejudice the criminal trial in any manner.
And my lord, district magistrate is very categorically and very rightly.
That I've seen, Mr.
Everything has been taken care of.
In my respectful submission, your lordship intention was never there because the last
sure,
but
one
one paragraph clearly says it is between.
Learned
WBCD.
counsel for the petitioner contends that the petitioner was a third party to a previous writ petition bearing WPA number 6313 of 2022, comma, which was disposed of with the order dated May 5, 2022 by this court, directing the respondent number 7 therein, that is the district magistrate, comma, Bankura, to decide the dispute between the writ petitioner therein, stroke complainant, the claimant, stroke claimant, and the WBACDCL for payment of compensation for the death of the said petitioner's husband by electrocution. Full stop. Next para, it is submitted that purportedly pursuant to the said order, comma, the district magistrate, comma, by the impugned order dated December 28, 2022, comma, decided the matter against the present petitioner.
Petitioners, lordship.
Petitioners, thank you. Petitioners, comma, who are local cable operators, comma, directing the petitioners to pay rupees 5 lakh between themselves to the claimant as compensation for their alleged involvement in the accidental death of the petitioner's husband. So it is argued that the district magistrate did not have the authority or jurisdiction under law to pass such an order directing the petitioners to pay compensation under any statute whatsoever. Full stop. Next para, that apart, comma, it is argued that even in the order dated May 5, 2022, comma, this court had specified that the court had not gone into the merits of the dispute between the WBACDCL and the petitioner therein regarding the liability and stroke or quantum of compensation while passing the said order, comma, indicating thereby that the dispute was exclusively between the WBACDCL and the claimant. Full stop. However, comma, the petitioners, comma, who were third parties to the writ petition, comma, were roped in, and subsequently compensation has been directed by the district magistrate, dehors the law and jurisdiction. Full stop. Next para, it is further submitted that a prior criminal case is pending against the petitioner on similar allegations, comma, which has reached the stage of filing of charge sheet. For substance, the petitioner's defense in the said matter would be directly and adversely prejudiced by virtue of the order impugned herein, comma, it is submitted that the district magistrate ought not to have passed the direction for payment of compensation. Full stop. It is argued that, comma, virtually, comma, taking advantage of the direction of this court, comma, the district magistrate has prejudged the criminal case against the petitioners, comma, which is palpably dehors the law. Full stop. Next para. Learned counsel appearing for the state respondent submits that the district magistrate acted well within his jurisdiction and strictly in terms of the direction of this court dated May 5, 2022, and there was no jurisdictional error or irregularity on the part of the district magistrate in passing the order impugned herein. Full stop. It is pointed out from the impugned order itself that the district magistrate took pains to give adequate hearing to all concerned, comma, including the present petitioners, and, comma, upon an elaborate consideration of all evidence, comma, including the statements of all concerned, comma, assessed the quantum of compensation after fixing liability on the present writ petitioners. Full stop. The said exercise, comma, as such, comma, could not be faulted and was well within the periphery of the direction of this court. Full stop. Next para, learned counsel appearing for the WBACDCL also makes submissions in similar tune. Full stop. It is contended that the order of this court dated May 5, 2022 was very specific and left ample scope for the district magistrate to give adequate hearing to all concerned and to come to a conclusion on the basis of inquiry or materials, comma, for the purpose of fixing liability. Full stop. The district magistrate has precisely done the same and, comma, as such, could not be faulted in any manner. Full stop. Next para, the statement of fact containing written instructions and a copy of the magistrate's order filed in court today by learned counsel for the state, comma, be kept on record. Full stop. Next para. Upon a perusal of the order dated May 5, 2022, passed in WPA 6313 of 2022, it is clear that, comma, undoubtedly, comma, the dispute in the said case had arisen between the claimant and the WBACDCL, comma, where the state was also a party. Full stop. The present writ petitioners are correct inasmuch as the said writ petitioners were not parties to the said writ petition. Full stop. However, comma, no rights of the present writ petitioners were curtailed by way of the said order. Full stop. Yet, comma, from the ordering portion of the order dated May 5, 2022, comma, it is clear that the district magistrate was directed to decide the dispute regarding the liability for payment of compensation on the occasion of electrocution of the petitioner's deceased husband. Full stop. For such purpose, comma, adequate hearing was to be given to, within double inverted, all concerned, double inverted close, and to come to a conclusion on the basis of inquiry or materials as deemed necessary by the magistrate. Full stop. Next para. In the present case, comma, the district magistrate complied with the said order and, comma, only upon due notice to the present writ petitioners and upon hearing them, comma, passed the direction of payment of compensation against the writ petitioners. Full stop. Next para. In fact, comma, as rightly pointed out by learned counsel for the state, comma, the order dated May 5, 2022 itself contained the rationale of the direction being given to the district magistrate. Full stop. It was observed by this court that the appropriate remedy of the petitioner would ordinarily be before a competent civil court, comma, since evidence on facts might be required to be taken for the purpose of deciding the dispute between the WBACDCL and the petitioner. Full stop. However, comma, in view of the financial condition of the petitioner, comma, who is a day labor, comma, such resolution of the matter by the civil court would go to the detriment of the petitioner rather than benefit her, comma, due to the apprehended time and resources which would be consumed due to pendency of the matter before the civil court. Full stop. On such premise, comma, the direction was passed. Full stop. Next para. It is noteworthy that the petitioners never took the point of jurisdiction before the district magistrate, but, comma, in full compliance of the direction of the district magistrate, comma, appeared before the said authority and advanced arguments. Full stop. After having submitted to the jurisdiction of the district magistrate and having made out their case before the magistrate, comma, only upon having lost in the said case by being saddled with compensation amounts, comma, the petitioners have chosen to prefer the instant writ petition. Full stop, next para. However, comma, the scope of interference under the present application under Article 226 is extremely limited, comma, more so since the petitioners themselves submitted to the jurisdiction of the magistrate instead of objecting to the alleged jurisdiction of the magistrate at the outset. Full stop, next para. That apart, comma, the petitioners have not challenged the order of this court dated May 5, 2022 as well. Full stop, next para. Hence, comma, the present challenge cannot be upheld on the ground of jurisdiction as raised by the petitioners. Full stop, next para. Moreover, comma, a mere perusal of the impugned order of the magistrate reveals that the magistrate entered into the merits of the case painstakingly and, comma, upon considering statements of the relevant witnesses and going through the materials on record, and after giving due hearing to the writ petitioners, comma, arrived at the conclusion that it was the cable operators in the area, that is the writ petitioners, comma, who were responsible for the accidental death due to their negligence. Full stop. As such, comma, a meager amount of rupees 5 lakh was directed as compensation to be paid together by the petitioners. Full stop, next para. In any event, taking into consideration the uneven social status of the writ petitioners and the claimant, comma, the claim, the amount directed to be paid as
erstwhile writ petitioner. Yeah.
erstwhile this writ petitioner, cable operators and the কি বললাম? Uneven social does not justify interference. Full stop, next para. However, comma, the petitioners are justified in apprehending that the said adjudication by the district magistrate might, comma, in the absence of any observation by this court to that effect, comma, affect the outcome of the criminal trial going on against them. Full stop, next para. Accordingly, WPA 12714 of 2023 is disposed of without interfering with the order of the district magistrate dated December 28, 2022. Full stop. However, comma, it is made clear that nothing in the order of the district magistrate and or this order or the order dated May 5, 2022 shall prejudice the petitioners in any manner in the criminal trial going on against the petitioners on the self-same allegation. Full stop, next para. It is further clarified that the scope of inquiry by the district magistrate in the impugned order, comma, being entirely in adherence to the direction of the writ court and limited to the assessment of the civil liability of the negligent party to pay compensation, comma, shall not have any direct bearing on the criminal trial. Full stop. The effect of the district magistrate's adjudication would only be to the extent that an otherwise civil adjudication in such regard would have on the criminal trial. Full stop. It is well settled that the standards of proof in a criminal trial and a civil assessment are entirely different. Full stop. The criminal court, comma, taking up the criminal proceeding against the petitioners shall keep in mind the above observations and accordingly decide the said case independently in accordance with law without being influenced unnecessarily in any manner by any of the observations made herein or in the impugned order of the district magistrate. Full stop. Next para. The compensation awarded by the magistrate, however, shall be without prejudice to the rights of the claimant to seek further compensation before a competent civil court, comma, if the claimant is of the opinion that the amount, the quantum of compensation given is not sufficient. Full stop. No rest to cause urgency.
Kindly add one line of my submission that the criminal court is sufficient to deal with the compensation if I am found guilty, because under the victim compensation scheme, they can.
Sixteen.
Good.
My lord, I beg to appear on behalf of the respondent number 2 to 4.
Yes, my lord.
You're for the petitioner? Yes.
I'm appearing for the
Respondent number 1, my lord.
petitioners before your lordship, my lord.
Would you please take the microphone a
Yes,
bit,
my
please?
lord. Petitioners, my lords, before your lordship, my lord, is an associations of manufacture of sponge and iron industries, my lord, and operating in the state of Chhattisgarh, my lord. My lord, for the purpose of running of these industries, my lords, that the allocation supply of coal, my lord, is required, my lord. And this coal is used to obtain, my lord, from the Coal India Limited, my lord. The Ministry of Coal, Government of India framed a guidelines, my lords, regarding the allocations of coal. And it was principally decided in that guideline that the allocations should be made on the basis of coal linkage auctions, my lord. And this auction should be held, my lord, on tranche basis, my lord. And in the guideline, it was specifically stated, my lord, that the floor price, my lord, that the initial floor price shall be fixed, my lord, as the applicable CCL and SCCL ROM price basis, my lord.
What is CCL and SCCL?
CCL, my lord, CIL, my lord, Coal India Limited, and CCL, my lord, Singrauli Coal Company Limited. It is a.
Pardon?
Central Coalfield Limited. No. CIL and SCCL, my lord. That is Coal India Limited and Singrauli Coal Company Limited. It is a coal company, my lord. It is jointly owned by the government of Telangana and government of India, my lord.
Right.
So, my lord, they are, my lords, my lord, they are, my lord, the controlling authority, my lord. They frame this guideline, my lord. So, my lord, this, my lords, price, my lords, the premium price, my lord, shall be, my lord, fixed, my lord, on the basis of ROM price, my lords, run of mines, my lord. So the coal, my lord, which is bringing directly from the mines, my lords, at the price, my lord, that price will be the base price, my lords. And on the basis of that, premiums, my lord, has to be, my lord, offered, my lord, by the bidder, my lord, on part-ton basis. This is the requirement, my lord. And, my lord, for the first 1 year, my lords, there will be no indexations, my lord, of the premium price, my lord. But subsequent years, my lords, it will be suitably indexed, my lord. So this is the requirement of the, my lord, the fixations of the price, my lord. This modality has been fixed, my lord. And thereafter, my lord, what and the Coal India Limited, my lord, was given the power, my lord, to enter into agreement, my lord, for a tenure not more than 15 years, my lord. So this is the basic guidelines of the allocations of coal, my lord. Then, my lord, the Coal India Limited, up to, my lord, the tranche 3 coal linkage auctions, my lord, strictly followed this guideline, my lords. There was no problem, my lord. Then, in respect of the 4th tranche of coal linkage auctions in the subsector of sponge and iron subsector, my lord, then, my lord, a new, my lord, price indexation method, my lords, has been introduced by the Coal India in clear deviations and in utter violations of the guideline framed by the Coal India Limited. I invite your lordship's attentions, my lord, to the said guideline, first, my lord, at page, my lord, 60 capital A.
The type copy, type page. 60 and 68.
Yes, my lord. At page 60A, this is type copy, my lord.
Yes.
Yes. Proportion of coal allocations between power and non-power sectors, 1, my lord. I will just read out the relevant part, my lord. At page 60A, my lord.
60 is the actual copy, 68 is
60A below typed copy, my lord.
16A, I'm sorry.
Yes, my lord. 68, my lord.
Yes.
Ah.
60A, you said?
Yes, my lord. 660A.
60, Acha 60 very well. Yes. Yes.
It is typed as in
No, 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 that I, yes.
Yes, my lord.
Right.
My lord, the paragraph Roman 1, my lord. The proportion of first, my lord, the proposal of competitive bidding for auctions of coal linkage and LOS to non-regulated sector, my lord, this is the, my lord, that the sponge iron, steel and the cements are non-regulated sector. My lord, this is non-power sector. To non-regulated sector has been under examinations in this ministry. With the approval of Cabinet Committee of Economic Affairs, the following policy guidelines for auctions of linkage of non-regulated sector have been decided. Proportion of coal allocations between power and non-power sectors may be continued at the same level as average proportions of the last 5 years, that is 75% power and 25% non-power. The Ministry of Coal may review the proportions as and when required. So this is the allocations, 25% of the total quantity will be allocated, my lord, for the non-power sector, my lord. But in respect of tranche 4, my lord, that allocations, 25% allocations has not been made, but there was a less allocations, my lord. And then, my lord, chapter.
But the Ministry of Coal may review the proportion. You
Yes,
said there has been no such.
No such review, revision. My lord, then page 61A.
Yes.
Paragraph 2. The broad guidelines for methodology for auction of coal linkage and LOS to non-regulated sector through competitive bidding shall be as follows. ACIL will allocate an armor coal from area or mine within a subsidiary as deemed fit. The tenure of new fuel supply agreement may be as decided by Ministry of Coal, subject to a maximum of 15 years. The methodology for auction of linkage shall be non-discriminatory ascending clock auction, where the auctioneer increments the price and the premium on the electronic platform till demand-supply equilibrium is established. In this methodology, prices shall be directed by the supplier coal company through algorithmic iterations. The initial floor price shall be set, this is important, my lord. The initial floor price shall be set at the relevant CIL and or SCCL ROM price, that's running of mine price, and bidders shall bid for premium above this price for the relevant grade and for a particular link quantity. If bids are received for quantity greater than link quantity offered, then the premium is increased in steps. Auction stops when bids are received for exact quantity, that is link quantity offered. Each successful bidder pays the same price. The method is illustrated in the table below. This is illustrations, my lord, per ton basis, my lord. Then, my lord, page, my lord, 62A.
Yes.
Paragraph F, my lord, subparagraph F. The ROM price to be paid shall be suitably indexed by CIL and or SCCL for subsequent years. The successful bid premium shall remain constant over the contract period. Maximum bid quantity by a particular bidder shall not exceed the normative requirement of the end user plant. So these are the, my lord, that the basic, my lord, the guideline, my lord, so for the allocations of coal linkage auction, coal through coal linkage auction. Then, my lord, I invite your lordship's attentions, my lord, to the scheme document, my lord. It starts from page 66, annexure P5.
Yes.
At page 99, relevant clause. Execution of the agreement.
Right.
The agreement, so my lord, all the successful bidder, my lords, is required to enter into an agreement, my lord. This is that agreement where this restrictive clauses, my lord, so for the fixations of price and indexations of prices concerns had been introduced in utter violations of the guideline, my lord. Right. So this is that agreement, my lord. The executions of the agreement shall be executed between the successful bidder and the relevant subsidiary in respect of the allocated quantity, from which subsidiary within 90 days of completion of sponge iron subsector tranche 4, coal linkage tranche 6, coal linkage auction based on the following. So this, my lord, this coal linkage auctions, my lord, in respect of tranche 6, my lord, has been completed, my lord, on 30th March, my lord, 2023, my lord. That would be apparent, my lord, at page 2013, my lord, annexure P7. 213.
Okay, yes.
Offer under tranche 4, tranche 6 NRS linkage auction for sponge iron subsector. My lord, at page 215, my lord, your lordships will find, my lord, that the last date of auction, holding auction 30th March 2023.
Serial 17.
Serial 17. Your lordships has got it at the bottom.
Yes.
Yes. So therefore, from that day, 90 days will expire, my lord, in June 2023, my lord. So 30th June 2023, my lord, each bidder, my lord, has to execute an agreement. So I have challenged, my lord, the certain restrictive clause, my lords, incorporated in this particular agreement, in scheme as well as agreement, in clear deviations of that guidelines. I will invite your attentions, my lord, to the model agreement, my lord. It starts from page 150, annexure P6.
Yes. Standard format.
First note at page 157, relevant clause I'll place at page 157. Commencement and terms of the agreement. The agreement shall come into force, paragraph 2.
Paragraph 2, yes.
Paragraph 2.1.
Right.
This agreement shall come into force with effect from the signature date. Subject to clause 17.1 and clause 17.2, this agreement shall remain in force and effect commencing from the signature date until the expiry of 5 years, except for steel and coking, etc. So, my lord, that the tenure of the agreement, my lord, has been fixed, my lord, for 5 years, my lords. Though the guideline said, my lords, up to 15 years, my lord, but there is no provisions for renewal clause, my lord. Why, my lord? Why, my lord, that the my lord, consumers will be suffered, my lord, that the manufacturers will be suffered, my lord, and why this guideline was, my lord, framed, my lord, for the benefit of the manufacturers, my lord, that, my lord, I will explain your lordship, my lord. My lord, after, my lord, placing the relevant clauses of this agreement, my lord. Then, my lord, I will invite your lordship's attention at page 170. One 169,
yes.
paragraph 11.
Price of contract.
Price of contract grade of coal. Yes. The price to be paid by the purchaser with respect to the contracted grade of coal delivered shall be computed on the basis of the following. Wholesale price index will be used for indexing of the basic price of NRS linkage auction by applying on prevailing modulated price as on 31st March of the year for the first year of indexing, that is on 1st April 2023, WPI, that is wholesale price index, will be applicable on notified price to arrive modulated price, my lord. So the definitions of no modulated price and the definitions of notified price, my lords, your lordships will get it, my lord, at page 155, my lord. Clause RR, my lord, at page 155.
Yes, yes.
Notified price shall mean the price of the relevant grades of coal as notified by CIL from time to time. Modulated price shall mean the price applicable for supply of coal and is higher of the indexed price and the prevailing notified price for NRS consumers. Then, my lord, for cost plus sources, there are, my lord, the price has been divided into two parts. Then for cost plus sources, notified price shall mean the price of the cost plus mine coal as notified by WCL from time to time. Then modulated price shall mean the price applicable for supply of coal from cost plus mine based on index price of WCL.
What is
So
this
therefore,
cost plus source?
Cost plus source.
The meaning of this?
Cost plus source, my lords, that the cost, my lord, when, my lord, that the coal, my lords, is bringing from the mines, my lord,
Yes.
that the cost paid, my lord.
Yes.
On thereon, my lord, that the indexed price, my lord, will be fixed, my lord, by the WCL. This indexations, my lord,
Cost plus
according to
source
the
means the source price plus the cost of
cost of the, yes, my lord. So this is the new introductions, my lord, in respect of the modulated price, my lord. And my lord, that is also subject to the further indexations, my lord.
Yes.
So, my lord, that the manufacturers, my lord, will be exposed, my lords, to the, my lord, to the variations of the price indexes, my lord, because it varies, my lord. Sometimes it, my lord, goes high, sometimes it, my lord, is goes down, my lord. But, my lord, because, my lord, that is why, my lord, that the 15 years maximum period, my lord, was time limited, my lord, by the, in the guideline, my lord, that was made. So that the, my lord, that the consumers, my lord, that the manufacturers, my lord, may absorb, my lord, this price, higher price fixations during the, in a stagger manner during a reasonable period of time, my lord. But here, my lord, that was fixed by 5 years, my lord. And that too, my lord, then I will also
price hike will be directly proportional to the market.
Proportionate to the market, my lord.
vagaries.
Proportionate to the market in the price indexations, my lord. This is, my lord, contrary to the guidelines, my lord. Absolutely.
Guidelines say up to 15 years.
And that is up to 15 years.
So
But so
up
far,
to 15 years may not mean 15 years. It may be lesser also.
maybe lesser by 5 years, or but that is why there should be a renewal clause.
Achha, very well.
There should be a renewal clause.
15 year that leeway must be there.
Yes. But there was neither any renewal clause nor any exit clause. Even, my lord, that the manufacturer is faced, my lord, due to higher fixations of the price, my lord, of coal, my lord, and which, my lord, rendered the manufacturing unit is, my lord, economic unviable, my lord. So there is no scope to exit, my lord, from this particular contract, my lord, because, my lord, otherwise, my lord, that the huge penalty will be attracted, that the security my lord, deposit, my lord, against the performance guarantee will be forfeited, and the, my lord, the manufacturers will be debarred, my lord, from participations in the all subsequent auctions, my lord. So, my lord, this is a heavy penalty, my lord, has been, my lord.
Exit clause is not in
The
deviation of the.
termination, my lord.
That is a commercial consideration you have to take into account.
Yes,
because you are also doing business.
Yes, my lord. No, there's no question. So that is why, my lord.
That is not in deviation of.
No, my lord. I want to.
The unjustness of it.
Yes, my lord. This is the, my lord, strangulating circumstances, my lord. So I agreed to this, my lord. But, my lord, at the same time, my lord, that the price fixations and the other, my lord, that the renewal clause should be there, my lord. At least, my lord, certain reasonable period, my lord, time should be given to the manufacturer, my lord. And then, my lord, that the another was in variable price was introduced by on the basis of percentage, my lord. But, my lord, earlier it was on ton basis, my lord. That the premium, my lord, was offered on ton basis, my lord. But in this, my lord, new indexations, my lord, that the price, my lord, has been, my lord, based, my lord, on per ton basis, on percentage basis. So, my lord, what is the difference? I'm explaining before your lordship, my lord. Suppose, my lord, if per ton, my lord, if it is offered per ton at the rate of 150, my lord, then, my lord, if it is, my lord, one minute, if it is fixed, my lord, premium, it is fixed at the rate of 150, my lord. Base price, my lord, and premium is given, my lord, 15, then it will come to 165, my lord. Then if it is percentage, instead of 15 per ton, if it is 15% as per ton, then it will be higher, my lord. And that too subject to further indexations, my lord. So therefore, my lord, that the price fixations, my lords, will go, my lords, to a higher extent, my lord. So, and this is absolutely, my lord, contrary to the guidelines, my lord, framed by the Coal India Limited.
Remain constant.
And under the guideline, my lord, that the premium shall remain constant, my lord. So first, and what is the premium, my lord? That the best price, initial best price of the fixed on the basis of the price of ROM, my lord, basis. That is one of mines. That means the cost which was paid for bringing the coal from the mines, my lord. So that is the base price. And on and above the base price, my lords, that the bidder will bid the premium, my lord. Say it base price was 100 and the premium bid was 15, my lord, then it will come to 115. This 115, my lord, exactly, my lord, that has been stated, my lord, and
14 page 31.
Paragraph 14 and page 31, my lord.
That paragraph. Example.
Yes, my lord. Paragraph
14, page 31.
Page 31.
31.
Yes.
Part of the page.
Yes.
প্যারা 13 থেকে শুরু হয়েছে, প্যারা 13 থেকে শুরু হচ্ছে।
Hmm.
প্যারা 13 14 থেকে
Ajay, that
Yes.
example has been given.
Yes, yes.
13 also
Yes,
প্যারা
yes.
13 থেকে
It is mentioned that the deviations from the para 13, my lord, at page 30.
13 already.
Yes.
Yes.
Aste, aste. It is mentioned that the deviations from the said guidelines of 2016 found in the said scheme of 2023 are also replicated mutus mutandis in the said model FSA, fuel supply agreement, to be entered into by the successful bidders, that is the prospective buyers, including premium fixation on percentage basis as opposed to per ton basis. Further, the price is also subjected to premium on percentage basis on the modulated price, subjecting the payable price of coal to further escalations upon which the buyer has to say once fastened, has no say once fastened with a fuel supply agreement in the standard form of the said model fuel supply agreement. Pertinently, the calculation of premium on percentage basis as opposed to per ton basis can result in unregulated price escalation for the successful bidders, that is prospective buyers. As a simplified example, if the premium is fixed at ₹5 per ton of coal having notified price at ₹100 per ton, that will result in total payable price of ₹105 per ton, including premium. If the premium is set at 5% of coal priced at ₹100 per ton, it will result in total payable price of ₹105. And if it is higher extent, my lord, it will be, my lord, more higher, my lord. It is a, my lord. However, if price of coal is escalated to ₹150 per ton, the price escalation for minimum calculated on percentage basis is drastically higher than premium calculated on per ton basis. In that event, price with ₹5 premium on per ton of coal would be ₹155 per ton, including premium, excluding GST, but price with 5% minimum on premium on notified price of coal would be ₹157.5 per ton, including premium, excluding GST.
No, second one is an example of the modulation, modulated price.
That is
Or the, it's a repetition.
That is, my lord, increase of price, my lord. Actually, my lord, on the
So there are two paragraphs of the example. The first paragraph I understand, yes, regarding the percentage and ton, that thing.
Yes, my lord.
What is the second on? The second paragraph, sub-paragraph? This is on the modulation. Or another example of.
Yes, my lord. Yes, my lord. Modulations.
If the price is increased in over the
Yes, my lord. If it is
examples
yes,
for the
my lord.
two,
Yes, my lord.
two
Yes,
deviations.
my lord. If it is fixed on percentage basis, my lords, then my lord, then the manufacturer will be sufferer, and by this process, my lord, the modulated price has been fixed, my lord. So that, my lord, this is higher of the notified price and higher of the indexed price also. Yes, my lord. So this is the positions, my lord. So, my lord, these guidelines, my lord, that in utter violations of this guideline, my lord, this restrictive clause, my lords, because taking advantage of the monopoly position, because the Coal India enjoys monopoly, because 90% market is being occupied by the Coal India. So therefore, my lord, taking advantage of that positions, my lord, they are forcing, my lord, or the manufacturers, my lord, or the consumers, my lords, to enter into a, my lord, agreement, my lord, at their sweet will, my lord, in clear deviations of the guidelines, my lord. And I invite your lordship's attention, my lord, at page 99, last, my lord. Last paragraph, at
Last
page
paragraph, 99, yes. FSA.
The fuel supply agreement executed thereof shall be valid for the entire tenure of the agreement. Any premature exit by the consumer buyer, except for the reason of exigence, force majeure, operational issues faced by supplying coal company, that is Coal India, not mine, including change in contracted grade and all this, shall attract following penal provisions for the consumer's buyer. Forfeiture of security deposit, debarment from participations in indemnity, immediately, next and or subsequent tranche of linkage auction after exit from fuel supply agreement. In case of the successful bidder fails to execute fuel supply agreement with the concerned coal company, post bidding except for the reason of exigencies and not force majeure and or operational issue faced by supplying coal company, including change in contracted grade, government regulation, the following penal provisions shall be applicable for the consumer and or buyers: forfeiture of earnest money deposit, bid security and process fee, debarment from participations in immediately next under subsequent tranche of linkage auction of the concerned tranche where the bidders has participated, that is blacklisting, my lord, almost blacklisting, my lord. So therefore, my lord, I didn't give it, my lord, any space, my lord, to absorb, my lord, the higher price fixations, my lords, during the reasonable period of time of 15 years. There was no renewal clause. Absolutely fixed for 5 years, my lord. And my lord, that the fix on the other side, that the fix is variable. When my lord it will go higher, my lord, I will not get, my lord, any chance, my lord, to reduce the price, my lord, because of the shortage of time. And the second, my lord, and the second thing, my lord, that the allocations was not made, my lords, as per proportions, my lord, indicated in the guidelines, my lord, that 75% to the power sector and 25% to the non-power sector. So, my lord, that the normative requirements of the plant, my lord, in Chhattisgarh, my lord, that the members of the associations are 83 manufacturers plant, my lord. They required, my lords, 11 million metric ton of, my lord, coal, my lord. It is their normative requirements, my lord. Whether, my lords, coal, my lords, has been put to auctions, my lord, only 6.5 to 7 metric ton, my lord. So therefore, there was a huge gap, my lord. So manufacturers has to, my lord, obtain supply of coal, my lord, from the open market, my lord. That will also force the, my lord, manufacturers, my lords, to expose the, my lord, higher prices, my lord. So that is that circumstances will also be absorbed, my lords, within this limited period. There was no renewal clause, there was no exit clause. If I find that it is not economically viable, my lord, I will have no options, my lord, to exit this agreement, my lord. Otherwise, my lords, I will be fastened with the, my lord, debarment, order of debarment, or the, my lord, blacklisting, my lord, and the forfeitures of the securities. So these positions, my lord, this is absolutely arbitrary, my lord, and taking advantage of the monopolistic positions, my lord, that the Coal India, my lords, included all these restrictive clauses, my lord. My lord,
you are challenging
now,
the scheme also in the.
it's a scheme and the certain clauses of the agreement, my lord, that the modifications are, I my lord, paid for modifications and or alterations, my lord. Because in the prayer, my lord, your lordships will find very
Clauses of agreement, can it be modified by the court?
No, my lord,
Can
that
be
is,
set aside.
yes,
but
my lord.
cannot
Yes,
be-
yes, my lord, yes, that your lordships, the fresh agreement could be entered into.
Otherwise,
If it is
modification
right, if it is found,
debarred.
yes, my lord, if it is right. Implementations of the guideline, that this has to be reframed.
whatever
Yes,
way it is.
that is, my lord. Then, my lord, that the questions may come up for considerations, the question of law, my lord. That the first, my lord, this is a guideline, my lord, policy guideline, my lord.
Binding effect.
Yes, my lord, binding effects. My lord, so I am, my lord, relying by, my lord, PM Minas, my lord, your lordships, that the, at least, my lord, that the guidelines, my lord, framed, my lord.
Yes, এটা আপনার OC
So we yet a note to it.
professed standard of the government.
My lord, the professed standard, my lords, laid down
Give
by
the
the
citation for him also.
yes, my lord. Said 1983, volume 4, SCC 582.
582.
582, BS Minas versus Indian Statistical Institute. Paragraph. Yes, my lord.
Paragraph 7 আছে
No. Frankfurter observation. Yes, my lord. Paragraph 23, my lord. The next question that arose for considerations is whether the appointment of respondent number 4 as director of respondent number 1 is illegal because of non-compliance with bylaws 2. Bylaw 2 does require that before appointment, the vacancy in the post of director should be suitably publicized. In the instant case, it is admitted on both sides that no publicity whatever was given in respect of the vacancy. The contentions of Sri Gorg, however, is that the bylaw having no force of statute, non-compliance with its requirement cannot in any way affect the appointment of respondent number 4 as director of respondent number 1. Sri Tarkunde, however, contended that assuming that the bylaw is not statutory, even so respondent number 1 was bound to comply with it. In support of his contentions, he strongly relied upon Ramanna Dayaram Shetty versus International Airport Authority. The court is that case held. It is well settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its action to be judged, and it must scrupulously observe those standards on pain of invalidations of an act in violation of them. This rules was enunciated by Mr. Justice Frankfurter in BHATTACHARYA versus Satan, where the learned judge said an executive agency must be rigorously held to the standards by which it professes its action to be judged accordingly. If dismissal from employment is based on a defined procedure, even though generous, beyond the requirements that bind such agency, that procedure must be scrupulously observed. This judicial evolved rule of administrative law is now firmly established, and if I may add, rightly so, he that takes the procedural short shall perish with the short. The aforesaid principle laid down by Mr. Justice Frankfurter in BHATTACHARYA versus Satan has been accepted as applicable in India by this court in Amarjyoti Singh Ahluwalia versus State of Punjab, and in subsequent directions given in Sukhdev Singh versus Bhagat Ram, quoted the above referred observations of Mr. Justice Frankfurter with approval. In view of the pronouncement of this court on the point, it must be held to be obligatory on the part of respondent number 1 to follow the bylaws. If the bylaws have been framed for the conduct of its affairs to avoid arbitrariness, respondent number 1 cannot therefore escape the liability for not following the procedure prescribed by bylaw 2. But in Sukhdev Singh's case, my lord.
Do you say these guidelines are of the status of a bylaw?
No, my lord. Guideline, my lord.
Bylaw is on a much higher footing.
Yes, my lord. My lord. Yes, my lord.
Some statutory force, even if
yes,
not.
my lord. Yes, my lord. That the standard, my lord. That the standard and norm, my lord, laid down by an administrative authority, my lord. They themselves cannot deviate from that standard. So that's the principle, my lord. Because, my lord, in Sukhdev Singh's case, my lord, that the Supreme Court has held, my lord, that the all bylaws or subordinate legislations, including notifications, my lord, which control the power of the executive authorities, my lord, so that they cannot, my lord, exercise the power arbitrarily, my lord. So, my lord, to put a limitations on the power exercised by the executive authorities. So here, my lord, in this case, my lord, these guidelines, my lord, that is a, my lord, standard and norms laid down by the department. And this department is the controlling authority. So therefore, their own standard, they cannot deviate from their own standard or norms. That's my respectful submissions. And exactly, my lord, that the Minas has laid down this principle, my lord. And, yes, my lord. And in another case, my lord, which has been relied on in this case, my lord, also, this is Amarjyoti Singh Ahluwalia versus the state of Punjab and others reported.
That was discussed by
yes, my lord. 1975-3 Supreme Court cases 503.
503.
503. Now it is
at
true.
Page 510.
Now it is true.
At page 510.
Yes, my lord. At page 510, fourth line, my lord.
Continuation of 9th paragraph.
Continuations of 9th paragraph. Now it is true that clause 2.2 of the memorandum dated October 25, 1965 was in the nature of administrative instruction, not having the force of law, but the state government could not at its own sweet will depart from it without rational justification and fix an artificial date for commencing the length of continuous service in the case of some individual officers only for the purpose of giving them seniority in contraventions of that clause. That would be clearly violative of Article 14 and 16 of the Constitution. The sweep of Article 14 and 16 is wide and pervasive. These two articles embody the principle of rationality, and they are intended to strike against arbitrary and discriminatory actions taken by the state, where the state government departs from a principle of seniority laid down by it, albeit by administrative instructions, and the department is without reason and a departure is without reason and arbitrary, it would directly infringe the guarantee of equality under Article 14 and 16. It is interesting, this is very important, Lord, it is interesting to notice that in the United States, it is now well settled that an executive agency must be rigorously held to the standards by which it professes its actions to be judged, and it must scrupulously observe those standards on pain of invalidations of an act in violation of them. So this principle, Frankfurter, my lord. So any administrative actions, my lord. So, my lord, here, my lord, that the standard, my lord, has been laid down, my lord, in this guideline, my lord. They themselves cannot depart from the line, my lord. Then, my lord, that the questions is this, my lord, I'm asking for, my lord, certain, my lord, that the clause is incorporated in the agreement, my lord. It's a contract, my lord. So, my lord, it is, my lord, as your lordships, my lord, well, our, my lord, since, my lord, 1979, Ramana Dayaram Settis, my lord, Milords, prior to that, Milord, that the threshold of the contract, Milords, invocations of judicial reviewable power, Milord, was Milord permissible, Milord. But after Milord, Lotus Hotel, Milord, the versus Gujarat Financial Institutions, Milord, that even after conclusions of contract, Milord, if there is any arbitrariness on the part of the state actions, Milord, then Milord, that the jurisdictions could be invoked. If that was subscribed, Milords, by passage of time, by many judgments, Milords, ABL International, latest Milords, and this MP power, Milord. In this case, Milord, that the Supreme Court has held, Milord, that the even, Milord, in a non-statutory contract, Milord, if there is any arbitrariness on the part of the state authorities, Milord, then the judicial reviewable power, Milord, could be exercised, Milord, under Article 226 of the Constitution of India. I invite your Lordship's attentions, Milord, to paragraph 56, Milord. এটা কোনটা
এটা নাই
না নগদ দিচ্ছে না
2023 বলুন
2023 volume 2 SCC 703.
This has discussed all the category of
If this were all this judgment, Milord, what I have, Milords, Milord, before your Lordship, all have been considered, Milords, in this judgment, Milords. Paragraph 56, Milord, first, Milord. I invite your Lordship's attention to paragraph 56, first.
Yes.
In Ramanna Dayaram Shetty International Airport Authority of India, this court inter alia held as follows. Now there can be no doubt that what para 1 of the notice prescribed was a condition of eligibility which was required to be satisfied by every person submitting a tender. The conditions of eligibility was that the person submitting a tender must be conducting or running a registered second-class hotel or restaurant, and he must have at least 5 years experience as such. And if he did not satisfy these conditions of eligibility, his tender would be ineligible for consideration. This was the standard or norm of eligibility laid down by respondent 1, and since respondent 4 did not satisfy this standard or norm, it was not empowered to respondent number 1 to entertain the tender of respondent number 1. It is a well-settled rule of administrative law that an executive authority must be rigorously held to the standard which I have just reiterated, Milord, Frankfurter's observation. Then, Milord, paragraph, Milord, 82, Milord, where, Milord, that the Supreme Court has called out, Milord, Milord, in a summary manner, Milord, at 82, Milord, at page 763.
Got it. Yes.
Yes, Milord. That it is undoubtedly true that writ jurisdictions is a public law remedy matter which lies entirely within a private realm of affairs of public body, may not lend itself for being dealt with under the writ jurisdictions of the court. The principle laid down in Barely Development Authority that in the case of a non-statutory contract, the rights are governed only by the terms of the contract, and the decisions which are purported to be followed, including Radhakrishnan Agarwal, may not continue to hold good in the light of what has been laid down in ABL International's, Milord, and as followed in the recent judgment in Sudhir Kumar Singh. The mere fact, this is important, 92.3, the mere fact that relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its actions or inactions under the contract. If the complaining party is able to establish that the actions and or actions is partially arbitrary, then 82.4, and actions will lie undoubtedly when the state purports to award any largesse, and undoubtedly this relates to the stage prior to the contract being entered into. This scrutiny, no doubt, would be undertaken within the nature of the judicial review, which has been declared in the decisions in Tata Cellular versus Union of India. Yes, Milord, but in our case, Milord, yet we have not entered into the, Milord, contract, Milord.
That stage has not
Milord.
been-
Yes, Milord. After the contract is entered, into there can be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by filing a writ petition, even after entering into a contract, Milord,
Yes.
which was held even in case of, Milord, Lotus Hotel in year 1981. Then, Milord, 82.10. The reach of Article 14 enables a writ court to deal with arbitrary state actions even after a contract is entered into by the state. A wide variety of circumstances can generate cause of actions for invoking Article 14. The court's approach in dealing with the same would be guided by undoubtedly the overwhelming need to obviate arbitrary state action in case where the writ remedy provides an effective and fair means of preventing miscarriage of justice arising from palpably unreasonable actions by the state, my lord. Then paragraph 82.13. At page 766. At 82.13, a lodestar which may illuminate the path of the court would be the dimension of public interest subserved by the court interfering in the matter rather than relegating the matter to the alternate fora. So this is my case. This 13 is not applicable, my lord. Here, my lords, we are not challenging any clause of the because at the threshold, my lord. The arbitrary actions, because the guideline says something and they have put it in the contract, my lord, and compelling, my lord, that the manufacturer, because I'm bound, my lord, because I have to run, my lord, industries, I need coals, my lord. So therefore, my lord, I am bound to, my lord, accept this particular agreement, my lord. So this, my lord, my respectful submissions, my lord.
Continue with the hearing tomorrow in the, on Monday in this matter.
Yes.
Because I had given liberty to for a matter to be mentioned if it was not taken up.
Yes.
So I'll continue. I'll keep it part heard.
Yes.
Heard in part for
Yes.
further hearing on
Yes.
12th, June 12th. Please come back. The understanding is that you have finished for the time being, subject to
Yes.
reply.
Yes.
On Monday.
Monday. It will be on the list on Monday. Yes. The part heard.
Other matter of the list is released. Because my friend will take much time.
No.
Very well. Other matters are released. Apart from Mr. Pal's matter. Mr. Bihani, you are for the other side.
Yes, Lord. I am for the state respondent.
You're for the.
No, this one.
But I just now told my learned senior friend, I didn't know he was for the petitioner. I told him that
38.
whichever way the order goes, I'll be happy when he's appearing.
No, your glasses are new.
That has nothing to do with this.
Absolutely. It's a spectacle after all. Yes, Mr. Pal.
I'm challenging the tender, Lordship, floated by the Pollution Control Board for housekeeping job, Lordship. Lordship, directly come to page 48, Lordship, the tender.
Yes.
I am showing this, Lordship, 12th June 2023, 2 p.m. the last date for submission of tender bid. That is why, Lordship, it's urgent. For page 48, Lordship.
Yes.
Second box.
Right.
That is why, Lordship, it's urgent, Lordship. And Lordship, kindly turn the page 50, Lordship. E-tenders are invited.
Yes.
E-tenders are invited for selection of agency for housekeeping job under the West Bengal Pollution Control Board having its head office at Poribesh Bhavan, Salt Lake, such and such, and other regional offices situated within the state of West Bengal. So not only Kolkata, Lordship, other regional offices, Lordship, that will be described, Lordship, at page 52, Lordship. Which offices are these? Page 52, the West Bengal Pollution Control invites tender from the bona fide reputed agency for engagement of agency of housekeeping job under the West Bengal Pollution Control Board. Details of location of offices as follows. These 9 offices, I have to quote tender, Lordship, for these 9 offices. And that is housekeeping staff I have to deploy for these 9 offices, Lordship. I have challenged 2 clauses, Lordship. First clause, Lordship, kindly turn, Lordship, next page, Lordship. Page 53, clause 7. Office location. The bidder must have an office in Kolkata, West Bengal. Copy of trade license. Copy of trade license means that I have an office in Kolkata, that trade license is required. Lordship, this is a tailor-made condition. Why, Lordship? This is a e-tender, Lordship. So, Lordship, in each and every corner of India, even from the global tender, it can be treated. They can participate in this tender. Suppose a bidder may be participated from Bombay, Madras, or other state. It is not necessary that they have office, they have to fix an office in Kolkata, Lordship, because these are 9 districts are there. Why Kolkata? This is arbitrary, Lordship. No reason is there, Lordship, for fixing this thing. And Lordship, similar situation arises in another matter, Lordship. The coordinate basis passed an order, Lordship. Okay,
একদম সিমিলার নয় আছে দাদা নিয়ে এসেছি
থাক
দাঁড়া বলতে দে সব দেখে
Lordship, 5, Lordship.
Yes.
Clause 2 of the terms and conditions of the tender indicates that the bidder must be available for communicate at the address given in the bid.
Clause 7 is very explicit. Clause, the paragraph 7 of this judgment.
7.
10
That
kilometers.
on the point, Lordship. So, clause page, Lordship, para 8, Lordship, accordingly, dispute direction to the ASA hospital Asman to permit the petitioner to participate in the tender and consider the bids in a fair manner and to accept the documents with it. So, Lordship, this is the thing, Lordship, because it's arbitrary, Lordship. Because they have
Mr. Pal, the difficulties in this case, Justice Bhattacharya permitted the writ petitioner to participate. But if that is done, then others standing on a similar footing as you.
Lordship, that is why the authority cancelled the tender. As they have to publish fresh tender, deleting that point because this is for all.
Yes, yes.
So they have cancelled that and they have put it fresh
You
tender.
cannot be given that advantage solely. I mean, if it
Lordship,
has to be an
for all,
advantage.
for all, it's for all,
unnecessary.
it's for all.
So this is one aspect of the matter.
This is the one aspect of it. And Lordship, similar thing, Lordship, page 52, credential.
Yes.
Clause 2, Lordship. 3 numbers of credential / contract for last 3 years regarding similar type of work for at least 25 numbers of sweeping personnel deployed under one organization. Lordship, that means 25 minimum for one organization. 3 organization means 75. Lordship, this is also arbitrary, Lordship, because suppose they are asking for or they are seeking for a bidder who have that capacity of 75 numbers of sweeper or other personnel who can serve their purpose. Lordship, suppose I am engaged in one hospital wherein I have 100 of those type of staff. So I will be divided. They must ask for the number of personnel that is for their purpose, to serve their purpose, that we need 75 personnel. If I have 150 personnel in one hospital, one organization,
they may be on the thing that you have an experience of catering to different institutions.
Lordship, that is Union of India, central government, state government, autonomous body, any.
Oh, achha, achha.
Anybody. Organization like central government, state government, autonomous body, PSU. Anybody I can. Suppose I have 100 employees deployed in any PSU or central government in one organization. I'll be divided, but I have that capability. I have that credential, Lordship. This is also tailor-made condition. So I'm challenging these 2 conditions, Lordship, because I have that quality.
Why do you say tailor-made for whom?
Because tailor-made, because the person, first thing for Kolkata, Lordship, whose office is situated Kolkata, they will get the benefit, not others. Whose office is situated in Calcutta, he will get benefit. A few bidder will get benefit for clause 7, Lordship. And clause 2, Lordship, because it is tailor-made, the person who have engaged less number of employee in 3 or 4 hospital or 3 or 4 PSU, they will be benefited. Even I have more credential, I will not get the order. I will
not fixing the credential to the number of people you have.
Yes, Lordship.
But that may be the deployment in different sources.
They should be our employee. That is the clause. They should be our employees. There is a clause, Lordship, that they should be the employee of the contractor. So if 100 employee deployed in any PSU, they are my employee. Lordship, these are 2 points, Lordship.
Yes, what do you say, sir?
No, my lord, I, my lord, first of all, take the point of the maintainability of the writ petition.
Why?
Because, my lord, my lord, lordship will kindly see, so, my lord, as the principal employer, my lord, I have the right to, my lord, fix the tender eligibility criteria subject to, my lord, it cannot be arbitrary, illegal, as your lordship or witness very unreasonableness.
Yes, yes.
Now, my lord, let me first of all, my lord, take your lordship to these conditions which my lord senior
Condition has to have a nexus with the purpose
Yes,
also.
absolutely. Otherwise, my lord, he has to show that your lordship's judicial review will extend to that. Now, my lord, kindly takes the 2 conditions which is impugned. Now, my lord, kindly takes page 53, clause 7, which was the first condition, the office location. Now, my lord, we say that the bidder must have an office in Kolkata and in West Bengal. But we say an office. Will we never say the head office? Now, my lord, kindly visualizes the nature of the tender. Lordship will find the nature of the tender work at, my lord, page 47. For 47, this is for housekeeping jobs. Now, my lord, the petitioner says, I have this was a partnership form, now it has been changed, it was sole proprietorship, now changed to partnership. I have my office in Katua. Now, my lord, the nature of the job is such that if tomorrow I require personals for some work, but if there is no office within the region, I do not say, my lord, my learned friend, which has produced the order of a coordinator before lordship, that had stipulated a condition which can be called unreasonable because it had said within 10 kilometers. I say within Kolkata. Because, my lord, tomorrow if I need a job on an urgent basis, he has to send his personnel from Katua.
No, Mr. Bihani, it may very well be that I have an office in Kolkata,
He
but
doesn't.
but my personnel come from Katua.
He says in the writ petition, I do not have an office in Kolkata. That is his bone of contention.
It might have been other way around because the personnel of this person may not come from his office.
Well,
I mean, office may be situated somewhere and the personnel may be based in Calcutta.
kindly sees his government in the.
If he has an office in Katua and he arranges for personnel from Kolkata, then he may outsource them also.
He doesn't say so. Kindly have a look at his government.
Not say so. But
he
what
says
is
in the government, he says the opposite thing. He
by
says that
having an office in Kolkata, how does that make a difference? Because office in Kolkata does not mean that I have my personnel in Kolkata also. I can resource out personnel from Calcutta. I may have personnel in Calcutta in every district of West Bengal.
Two submissions.
Office in Kolkata is not a relevant consideration at all.
Two submissions. And apropos this, subject to your lordship's consideration. One, but he doesn't say so. If he says that when he submits that also before your lordship, my lordship will kindly ask him. Number one, that in case of emergency,
it is not to not to be tailor-made for him also.
This has to be for you. This has to be universal.
No, universally, Mr. Bihani, just tell me that how can it be that the people personnel do not reside at the office?
No,
I may have personnel everywhere.
Yes,
and I may not have an office in.
But out of 9 branches of the Pollution Control Board, 5 are in or around Calcutta.
Paschim Bardhaman, Siliguri, Hooghly. Yes, Hooghly is nearby.
In and around within the vicinity of Kolkata.
Not
now,
necessarily.
will this
you know where Narayanpur is? This is Panpur Mun Narayanpur. Where is that?
Lordship is that?
3, page 52. That is Barakpur.
Barakpur, village Panpur. Then Siliguri Regional Office, Holdia.
Even Poribesh Bhavan is not in Calcutta.
Calcutta 91.
It's Salt Lake City, Vidhannagar, as per you.
Quite far from Kolkata.
Not 24 Parganas for district purpose.
Oh, that is personal knowledge. No, let us come in. Kindly say, but will this condition?
Kolkata is not.
Will this condition?
What about credential? Why 3 places? 2.
That's one. Total yes. Now, kindly takes now, apropos that credential, kindly takes page 55 also once. Clause 4. Over here, the credentials have been giving a marking system with the commensurate to the certificates being issued. Now, the Pollution Control Board has tried to ascertain that you have a expertise or the experience in providing the manpower. But will these conditions or the alleged violations, can the petition invite your lordship to exercise the judicial power to go into the realms of contract to this extent? I'll cite certain decisions on this.
Now, how do you relate this 4 with the others?
Because clause 4 is an offshoot of clause 2 of credentials.
3 numbers credential contract.
Clause 2 kindly sees 3 number of credentials or contract for last 3 years regarding similar type of work for at least 25 numbers of sweeping personnel deployed under one organization, like such and such.
This is a bid evaluation criteria. This is in consonance with eligibility criteria.
Yes.
You cannot rely on one to support.
No. This is in consonance with it.
Yes.
So therefore, in consonance with this, whatever is known, marks will be allotted. So what my learned
you first.
This is not tailor-made.
Suppose not tailor-made. What is the nexus between this and the purpose of the? Because you want only one of the offices probably is in proper Calcutta. That is in Alipur. See, all the other offices, it could have been very well in Dankuni. One is in Dankuni, one is Bidhannagar, one is Narayanpur, Panpur More.
Kindly see the vicinity. This is all in and around Kolkata. And Bidhannagar from Kolkata is...
There are 2, one is from Siliguri, one is for Siliguri.
Yes.
Yes, there are 2 Kolkata.
Out of these 9,
5
out of these 9, 5 are in and around Kolkata. And my lord, number two, my
You
lord,
should have
this
an
is-
office here, I don't understand. Because you are restricting people from all the districts. That is the difficulty.
no, I'm subject to, I'm not restricting people. My lord, or
I may not
rather,
have an office here. I may operate from Katua, suppose, as he's operating. Because I'm taking the example of Katua.
he doesn't have an office here. He says that in his government. He says that since I do not have an office over here, you are restricting me.
He may not have an office in
Yes.
Kolkata.
Yes.
Why should he? He may have an office in Katua.
Very well.
And he may source people from here in Kolkata if it's needed for Poribesh Bhavan.
Kindly look at his government.
Office does not contain the personnel.
But will that, my lord, subject to recognition, will that want of office that you have it will lead to unreasonable unreasonableness to interfere with it at this stage when it was floated on
It's not
25th?
Wednesday, but it is
On 25th.
Friday.
Well, lord, it was floated on 25th. He knew of it. It comes today before your lordship on when Monday is the last day.
That's why Friday very test.
No, my lord, will your lordship have a look at one or two decisions on this?
Oh, yes. Cite the decisions.
But I will also cite Milord one or two decisions on behalf of the state government.
Kindly takes this.
Yes.
My lord, lordship is aware of this decision, but still.
No.
Yeah, Dada, obviously. Well, this is 2026, volume 16, Supreme Court cases, page 489, Shilpi Constructions.
Yes.
No, kindly takes only 3 paragraphs, 19, 20,
Mr.
and
Bian,
20.
you are for which respondents precisely?
Well, I am appearing.
Everyone else than the state.
Well, I appear for 2, 3, and 4.
Very good. Yes. Please
No,
continue.
kindly have a look at paragraphs 19, 20, and 25. Well, may I just take your lordship to that? Paragraph 19 is at my lord at page 501. Well, may I place it? Well, this court being the guardian of fundamental rights and everything may not be important, is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. However, this court in all the aforesaid decisions has cautioned time and again that courts should exercise a lot of restraint while exercising their power of judicial review in contractual or commercial matters. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made out. One must remember that today many public sector undertakings compare with private industry. The contracts entered into between private parties are not subject to scrutiny under writ jurisdiction. No doubt the bodies of state within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to the writ jurisdiction of superior courts. But this discretionary power must be exercised with a great deal of restraint and caution. The court must realize their limitation and the havoc which needless interference in commercial matters can cause. In contracts involving technical issues, this is not technical. Lordship will glance through this. As laid down in the judgment cited above, the court should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. In fact, the courts must give fair play in the joints to the government and public sector undertakings in matters of contract, must also not interfere with such interference to cause unnecessary loss to the public exchequer. Number kindly takes the next paragraph. The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution. The need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of the expert unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the base judge of its requirements, and therefore the court's interference should be minimum. The authority which floats that contract or tender and has authored the tender documents is the base judge as to how the documents have to be interpreted. The next line is may not be. Kindly takes very important paragraph 25. That brings us to the most contentious issue as to whether the learned single judge of the High Court was right in holding that the appellate orders were bad since the. We must remember that we are dealing with purely administrative decisions. These are in the realms of contract. While rejecting the tender, the person or authority invoking the tender is not required to give reasons, even it be a state within the meaning of Article 2 of the Constitution. These decisions are neither judicial nor quasi-judicial. If reasons are to be given at every stage, then the commercial activities of the state would come to a grinding halt. The state must be given sufficient leave in this regard. Such.
What is the question of reasons here?
No, because the reasons will not come over here because they have not entered into the bid and they are not finalized. So, but the other points, as in paragraphs 19 and 20.
19, 20.
My lord, this is my first decision. Only two more, my lord, kindly takes the second. My lord, these are all lordships have held, referred to this time and again. This is a decision of our honorable court. Well, reported in 2018, SCC Online Calcutta 47
contract is to be left to the decision of the employer. Full stop. Next para. Mere technical violations, comma, in the absence of any patent arbitrariness or intended malafides, comma, cannot call for judicial interference, comma, it is argued. Full stop. Next para. Upon hearing learned counsel for the parties for the purpose of consideration, for the purpose to ছেড়ে দাও. Upon hearing learned counsel for the parties, comma, scrutiny of the relevant clauses gains vital importance. Full stop. Next para. Insofar as the serial number 7 of the tender document is concerned, comma, the office location of the bidder has been stipulated to be in Kolkata, comma, West Bengal. Full stop. The clause provides that the bidder within double inverted must, double inverted clause, have an office in Kolkata, comma, West Bengal. Full stop. The same defeats logic from all perspectives. Full stop. Next para. First, comma, the work contemplated in the tender pertains to 9 offices of the West Bengal Pollution Control Board. Full stop. Out of the said offices, comma, only 2 are situated in proper Kolkata. Full stop. Although learned counsel for the respondent numbers 2 to 4 is justified in submitting that some of the other offices are also in the vicinity of Kolkata, comma, even otherwise, comma, the offices at Barakpur, comma, Shiliguri, comma, Holdia, comma, Hugli, Asansol and Durgapur cannot be said to be within the territory of Kolkata. Full stop. Next para. That apart, comma, the said clause has no direct nexus with the purpose of the contract, which is to provide personnel for the purpose of household maintenance activities. Housekeeping activities, household maintenance, housekeeping activities. Full stop. Next para. It may very well be that a particular stakeholder does not have any office in Kolkata, but has sufficient manpower to provide such personnel for the purpose of deployment in the respective 9 offices as stipulated in the notice inviting tender. Full stop. Next para. Moreover, comma, there is a wider perspective to be considered. Full stop. In the event the office, in the event the bidder is restricted to having an office in Kolkata, even for the purposes of eligibility criteria, comma, several people placed on an equal footing as persons having office in Kolkata, comma, spread over in the districts of West Bengal, comma, shall be precluded at the outset from participating in the contract, comma, thereby depriving the tender issuing authorities, comma, who are government functionaries, comma, from having a much wider and varied participation in the contract, in the tender. Full stop. Next para. As held by the learned single judge in Messrs. Rupa Enterprises versus the state of West Bengal in WPA 11519 of 2023, comma, the competition ought not to be narrowed down by introducing an unreasonable clause in the participation process itself. Full stop. The court further held that the restriction introduced in a particular clause of the relevant tender therein, comma, restricting participation to bidders having physical office in the vicinity of 10 kilometers was unreasonable and arbitrary. Full stop. Next para. The same logic applies in the present case as well. Full stop. The stress sought to be laid by learned counsel for the respondent numbers 2 to 4 in the number of kilometers mentioned by the learned single judge does not hold any relevance to the ratio of the said judgment. Full stop. The principle laid down therein is in consonance with the above observations of this court as well. Full stop. Next para. Insofar as the judgment rendered by the Supreme Court in Silpi Construction Supra, comma, in the said matter, the Supreme Court observed that the court can only interfere in cases of arbitrariness, comma, irrationality, comma, malafide and bias. Full stop. Although, comma, in the present case, comma, no specific malafide has been made out by the petitioner, at least prima facie, comma, there undoubtedly is arbitrariness and irrationality in the clause in question, comma, since the restriction of the bidders to have an office within the territory of Kolkata mandatorily frustrates the entire purpose of seeking a wide participation from all corners of the state for the purpose of housekeeping jobs. Full stop. Next para. Merely having an office within the periphery of Kolkata does not have any relevance or nexus with the purpose, which is to supply manpower for the purpose of manning 9 offices of the Pollution Control Board, comma, spread over different parts of West Bengal. Full stop. Next para. This bias towards Kolkata, people having offices in Kolkata, comma, which is the main seat of administration, comma, is unjust, comma, irrational, and has no nexus with the purpose of the tender. Full stop. Next para. Insofar as the judgment of Michigan Rubber is concerned, comma, in the said case, the Supreme Court laid down certain principles which cannot be disputed. Full stop. The Supreme Court, comma, inter alia, comma, stressed on the basic requirement of Article 14 and observed that in the matter of formulating conditions of a tender document and awarding a contract, comma, greater latitude is required to be considered to the state authorities unless the action of the tendering authority is malicious and a misuse of the statutory powers. Full stop. Certain preconditions or qualifications for tenders were held to be mandatorily to be laid down to ensure that the contractor has the capacity and resources. Full stop. Next para. Applying the same tests to the present case, comma, the resources and the competence of the contractors has no connection whatsoever with the contractor having an office within Kolkata. Full stop. Having an office in Kolkata is not such a hallowed, H-A-L-O-E-D, hallowed proposition which will sanctify the incompetence, comma, otherwise, comma, of certain bidders, comma, in the event they fail on the score of supplying adequate personnel to man the offices of the Pollution Control Board. Full stop. Next para. The division bench, comma, in the judgment of Renesco India Limited Supra, comma, also stipulated certain yardsticks of interference by the court. Full stop. It was held that the court does not have the expertise to correct an administrative decision. Full stop. If review of an administrative decision is permitted, comma, it was observed that it will amount to substituting the court apostrophe s decision without the necessary expertise. Full stop. However, comma, in the present case, comma, no particular expertise is required to see through the patent violation of Article 14 of the Constitution of India as well as Article 19 of the Constitution, comma, inasmuch as people not having an office in Kolkata and not centered in Kolkata, comma, even though otherwise competent and located or based in other parts of the state, comma, would be deprived at the outset from participating in the work concerned. Full stop. Hence, comma, there is a patent ingredient of violation of the said articles in the impugned clause number 7. Full stop. Next para. However, acha, insofar as the judgment cited by the state is concerned, comma, this is not a case where the tenderer is seeking to dictate terms. Full stop. The essentiality of a particular clause definitely has to be decided by the employer. Full stop. However, comma, clause serial number 7, comma, that is pertaining to the office location, comma, cannot by any stretch of imagination be an essential clause from any perception, from anybody's perception. Full stop. Next para. In fact, comma, the said clause has no nexus with the purpose of the contract as reiterated above, and comma, hence, comma, does not stand the scrutiny of a reasonable person or even the Wednesbury principle harped on HRPED, harped on by the respondent numbers 2 to 4. Full stop. Next para. However, comma, insofar as serial number 2 regarding the credentials complained of by the petitioner is concerned, comma, the same, comma, in all fairness, comma, does not stand the test of Wednesbury principles. Full stop. The employer, the tender issuing authority, comma, in its wisdom, comma, required that the prospective bidders have the credentials regarding contracts for the last 3 years, comma, which is a reasonable period, comma, for at least 1/3 of the number of personnel required, comma, for 3 similar types of work, comma, totaling to 75 numbers of personnel. Full stop. Moreover, comma, under the said serial, comma, the employer seeks that the previous experience must be confined to 3 different types of work under the same organization. Full stop. The same yardsticks are applicable to the present case as well, comma, since all the 9 offices belong to the West Bengal Pollution Control Board, that is the same employer, and the workers will be deployed to different places at the same time. Full stop. A coordination between the said personnel by the same bidder is a necessary prerequisite for the purpose of such deployment. Full stop. It may very well be that a particular contractor has several personnel under his care, but find it difficult to coordinate and deploy such personnel in different places in West Bengal simultaneously. Full stop. Hence, comma, the authorities cannot be faulted on the ground of the credentials sought at serial number 2 of the eligibility criteria in the NIT. Full stop. Next para. However, comma, on the score of introduction of an irrational clause by way of the office location being stipulated to be in Kolkata, comma, the said clause has to be set aside. Full stop. Next para. In such view of the matter, comma, the petitioner has made out a strong prima facie case for the writ petition to be heard on merits. Full stop. Next para. Hence, comma, should I stay the operation, Mr. Bihani, or whatever you say? At this point of time, you may submit something which I'll record.
Lord, I have submitted what I had.
At this juncture, comma, it is submitted by learned counsel for the respondent numbers, for the respondents, or respondents 2 to 4.
Lordship, make it the court's order.
Learned counsel for the respondent numbers 2 to 4, that any interim order passed in the matter.
My Lordship kindly makes it a court's order, because I am absolutely without. This was my.
You're opposing.
No, this was.
Will render the matter infructuous.
This was my submission from the bar. I received it yesterday at 9 PM in the night.
So you're not submitting anything.
Well, I've submitted on merit, Lordship has discussed.
Whatever you have submitted up to this, up to what I have recorded. তাহলে এই last line টা ছেড়ে দাও, বুঝছো? In such view of the matter, comma, the Mr. Bihari, the option is two. One is that the entire tender will be set aside because court cannot modify an agreement. Either it has to be set aside, or I can pass an illegal order setting aside this clause only.
Let it be a
Then
court.
it has to be by a corrigendum.
The Lordship will decide on that. Well, I have nothing to submit on this.
Very well. Push up. Next paragraph.
Kindly see, Mal, what is the base for?
Next sentence. I'll do whatever my judicial. Hence, comma, the petitioner is entitled to an interim order as paid for in the writ petition. Full stop. Next para. However, comma, applying judicial prudence, comma, it is evident that in the event the tender process is stayed outright and or set aside at this mature stage, comma, the same will involve much further expenditure of public money. Full stop. That apart, comma, in view of the nature of the urgency of the job sought to be achieved by the tender, comma, a blanket setting aside and or stay of the tender process would inure to nobody apostrophe's benefit. Full stop. Next para. Hence, comma, since no specific prayer for filing affidavits has been made by the respondents, and in view of the present adjudication being limited to the legality and constitutionality of the clause concerned, comma, there is no need to keep the matter pending further unnecessarily. Full stop. Next para. Accordingly, comma, WPA number 13404 of 2023 is disposed of by restraining the respondent authorities from proceeding further with the tender in its present form, with the impugned tender in its present form. Full stop. However, comma, it will be open to the respondent authorities to issue a corrigendum deleting serial number 7 from the eligibility criteria of the impugned notice inviting tender, and thereafter, comma, to hold the tender with the rest of its clauses intact, comma, by extending the date of participation and the corresponding dates as given in the notice inviting tender subsequent to a subsequent period. Full stop. Next para. It is made clear that in the event such corrigendum is issued by the respondent authorities, comma, the respondent authorities can proceed on the basis of such corrigendum, comma, merely by extending the corresponding dates for corresponding last date for submission of the bid and the other dates appearing in the notice inviting tender accordingly. Full stop. So, but you cannot give effect to this tender as it is. So tomorrow's 12th June's thing goes, you have to issue corrigendum. You can do it tomorrow also or day after tomorrow. You have to issue corrigendum. After that, you have to also extend the dates corresponding.
The corresponding dates.
Corresponding dates, the rest of the clauses remain intact.
My lord, which is at page 51.
51 is what?
51 is my lord, all the scheduled dates. 51 of the writ petition.
You have to reschedule the dates.
Page 48 also.
48 also.
48 also.
48, 51, yes. 51 is a better version, yes.
He has to reschedule the dates.
You have to reschedule the entire dates.
Submission of tender.
Last date of submission from that. Clause onwards, yes. I'll put something corresponding dates যেখানে বললাম from the bid submission closing date onwards. From the bid submission closing date onwards, so that the rest of the thing remains.
Much obliged.
May I give back the books?
No. Those will be kept for say some time till you forget, and then the court will usurp. Yes. এগুলো দেখে নিয়ে এগুলো অনিন্দিতা এগুলো তুমি নোট করে নিয়ে নামগুলো পার্টির নামগুলো নোট করে সাইটেশন গুলো নোট করে ফেলছো।
Or when I submitted at the initial stage Wednesday, I knew something will come.
If I can't reach, then also on
maybe-
Monday in the first at the first sitting, just mention it. Like Mr. Pal, I'll give you liberty to come back before
Or maybe
it is.
get the order today so that my lord I can communicate it. Because it has to be,
Whatever, I mention it on Monday in the morning when I sit. And if I can't reach, then I'll give you liberty as I gave to the present this petition.
or if you may, can you get the order by today so that my lord
This
can-
will be typed, say within 4 hours, it will be
no,
typed.
by any time by today.
Within 4 hours, it will be typed definitely. I can assure you that. And if it's typed within 4 hours, it won't be uploaded today then.
Last date is Monday.
সবকিছু ছেড়ে আগে এটা তুমি টাইপ করো, বাকিগুলো তোমার পরে দিও। Let us try, I'll try to get it uploaded today itself.
I'm deeply-
এটা আপলোড করতে হবে।
deeply
Grateful.